What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Everything that guy just said is bullshit. Thank you.
Hey, sorry. Missed it by that much. Just click that one last one, just that much. Hey, good morning, good afternoon, good evening. How are you? Hi, it's me, Legal Vices, and I'm talking really fast because we have a lot to do today. We have a huge amount of stuff to get through here. We have 4 huge motions. The chances of me actually getting through everything are slim to none. We're going to do our best here. If not, we'll make it up on Friday. So that's what we're going to be doing here. All right. Well, geez, where to start? First of all, just do all the back of the house stuff as quickly as possible. We have our like and subscribe poll up. We've already got 313 people here waiting and only 100 and something likes. What's the actual number on that? So I know how many people to yell at. 169 likes. Well, 69 plus 100. That's good enough-ish. All righty. So 331 of you here, 173 likes by my lawyer math. That means 50% of you haven't done your job. Get down there and smash that like button. You're here, you're watching it, you're liking it. You've been here for more than like 12 seconds. You got to be liking it. Be here. So smash the like button. Hit the subscribe button if you have. If you haven't done so, if you have, just double check to make sure you are subscribed because YouTube is asshole and they like to delete subscriptions for no reasons. But just double check for that for me. Then take our like and subscribe poll. The like and subscribe poll today may be the worst one I've ever done. I had a really clever one that had a lot of really clever answers, at least in my brain. And I thought I put it up there. I guess maybe I didn't. I guess maybe I didn't save it and I lost it and I just didn't have time. So today's like and subscribe poll is really lame. JHACH defense, dumb, dumber, dumbest, childish poll, but they are stupid. Those are your choices today. Wow. So we've got a lot of stuff going. We've got motions, and we're doing it in the run up to the questioning of juror number 1 later today. I will be sleeping the sleep of the just. Starts like 5 a.m. my time. So this is just a warm up. This is just to wake you up and get the blood going while y'all prepare for the watching, the great watching that will happen at 3 p.m. Eastern time. And let's see. I guess I'll cover that on Friday. We'll do that on Friday. So I'll give my little review of it on Friday because tomorrow is O.J. Simpson Day. And then we're going to be having as far as I can tell, we're going to be having a very, very special What is Whiskey and How to Drink It stream on Saturday evening U.S. time. And that's about it for coming up. So we got O.J. tomorrow. We're finishing up with we're slowly winding down the closing argument. Then Friday we'll catch up on the JHACH stuff, the hearing, and anything we don't get to today. And then Saturday evening will be the whiskey, what is it, and how to drink it with a very, very, very special guest, a very, very close personal friend of mine who is popping into town for a couple of days. And just on the horizon, set your clocks, set your alarm, set everything for January 19th, Friday, 7 p.m. Eastern U.S. So it'll be Saturday morning at midnight a.m. in the UK and 11 a.m. In Canberra. That is our January F at Friday. This is going to be like unlike any other F at Friday we've done. And for those of you that don't know, F at Friday is it's a total griftathon where I just try to liberate as much money from you as possible in a once a month silly griftathon, so we don't have to beg for grift and beg, grift, and beg and plead for super chats throughout the month. We have a full panel, and we're going to be getting more. The current panel. This is a very special one because it's something that I'm calling Legal Vices Lady Bits. It's an all-female panel. And so far, let's see who we've got lined up. It's going to be all female, except for me, of course, because I'll be right there in the Alice of the Brady Bunch Center Square, the Paul Lynde Square, if you're elderly and watched Hollywood Squares. So far for lined up for the 19th, we've got Flux will be there, Lauren De Laguna, Jasmine Jafar, Surly Durley, otherwise known as Waifu Kron, Jess, Steph the Alter Nerd, Chandler Remington, Talk with Sally. Who else will be there? Christina Radix Verum will be there. Ari Jacob will be there. So we've got people coming in. as it goes on and on and on. So we'll have a great night. We'll just drink as long as my liver can take it, and you still have money in your bank account. All right, that's out of the way. Forget about that. We'll keep talking about it later as we go along. But now we need to get into the meat and bones of the things, which is all of the motions. We got tons of motions to get through. I have no idea how we're going to get through 2 short and 2 very long motions. As we leap into this, the first thing we got to take care of is all of the monthly memberships, the super chats, and all the things that have backed up here whilst I've been rambling. But hey, we did it in 6 minutes today. That's damn near a record. So, all right, folks, let's see what we've got locked and loaded here. The Wanderer. I highly suspect Judge Carroll has a legion of law clerks watching YouTube after yesterday's denial. It is pretty epic, and one way or another, we'll get to it. We'll get to it, even if we have to do things out of order. We're going to get to his motion because it was pretty funny. It was pretty darn epic. Manders 13. What's up, Manders 13? Gifted 5 Legal Vices memberships. If you got one of those, make sure you give Manders a super, super, super special thanks. Deeply appreciate that, Manders. Alan bringing the 69 heat all the way from Australia in the middle of summer. Jeff, I love you. Happy New Year. Happy New Year to you too, Alan. And thank you for being a supporter for 13 months. Bella Stella also dropping 10 Legal Vices memberships. Holy smokes. And that's pretty damn awesome. Thank you, Bella. And if you got one of Bella's, give Bella super thanks. And Marv White again. Good to see you here every day. Marv White with a $2 super chat. Are you fresh off the set of a spaghetti western? You know, it's just kind of warm in this thing. It was colder this evening, but the house kind of warmed up a bit. But yeah, this is my beater clothes. This is what I wear when I go winter camping, and this is the hat that the dogs ate. So I just reshaped it and repurposed it, and this is my beater hat. I haven't worn it for like months, so I thought I would just break out the old beater hat. Still got dog hair on it. Thank you so much for the super chat. And Volpe Fox, who's been a member for 6 months. Another month on Vices and another rotation around the sun on Earth. Happy birthday to me. Well, happy birthday to you, Volpe Fox. And I just want to say a super, super special happy birthday to you because I just happen to have a cocktail in my hand because I figured this was going to get heavy and heated, so I needed a nice cold cocktail. So cheers to you. Happy birthday, and hope to see you here in another year so we can do it again. Best wishes for everything. 2024. And finally, last but not least, just last because it came in last, gifted 5 Legal Vices memberships. There you go. Thank you so much. And give Ben there, done that, a super special thanks. If you got one of those 5 memberships, dang, how many is that already? Me no do math. That's 5, 15, 20. Cool. That's 20 memberships already. We are into it. So, all right. Without further ado, as the French say, we are going to be, great, there we go. Well, one monitor went blank, then both monitors went blank, and now they're both back on. So, phew, we dodged that one. All right, I was actually sweating there for a second when I start to look at the monitor where we need to bring up the main stuff we're doing today, and it just went blank, just pieced out on me, but we're back. All right. This is what we're getting into first. Plaintiff's notice of filing supplemental exhibits in support of response of defendant's post-trial motions. Oh my Lord. Sebastian Mueller also dropping 20 Legal Vices memberships. Yoink. Folks, that's quite generous straight out of the gate. Gosh, we're set. Give Sebastian Mueller a super special thanks. He has done what we like to call release the hose. It's that time. I never expect this to happen. So when it does, I'm always utterly unprepared. So all right, bring up extra doggo cam. Where's extra doggo cam? There's extra doggo cam. Put that up. Thank you so much. Thank you so much, Sebastian Mueller. Dang. All right. So until anything else happens, until they wander off or fall asleep or whatnot, here is 50% of the dogs. That's a Strawberry there, just kind of staring off into the space heater. Oh, you heard your name, did you? Good doggy. All right. Strawberry will be joining me, and maybe Yoda will join us some other time, and maybe Strawberry will just wander off. We just don't know, but they're here for now. So, all right. You all may remember that there was one of the main arguments that the defense were making was that the plaintiffs were evil in not getting rid of juror number 1, and juror number 1 was extra evil because he did not disclose that a lawyer woman had somehow represent. He was aware of her because he represented his wife in a former divorce proceeding. Well, that lawyer has something to say, and we're going to see what that lawyer has to say. Plaintiff's notice of filing supplemental exhibits in support of response to defendant's post-trial motions. Let's get it on. Plaintiff, Jack Kowalski, individually. Jack Kowalski is parent in front of MK, a minor, and Jack Kowalski. Now, Maya's 18. Don't they have to? They should be changing all of this. They should be changing all of this to her representing herself, or anyway, or her being an individual, not representing herself, her being an individual plaintiff, no longer a minor under her father's. But anyway, they don't necessarily have to do that if everybody agrees with it. But Jack Kowalski, a personal representative of the estate of Beata Kowalski, deceased, by and through the undersigned counsel, hereby filed this notice of filing supplemental supports in support of the response, blah, 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 blah. Exhibit A. Deborah Salisbury's affidavit. Hey, Jules. Dang. This is fun. This is a good motion. I mean, this is a good affidavit. Now, what is an affidavit? An affidavit is a sworn statement, a statement given under oath. In this case, a statement given under oath by an officer of the court, by a member of the state bar. This is just about as high of veracity, a high of truthfulness as you can possibly just give someone, which goes against the fact that Shapiro submitted his own sworn statement under oath that she was involved in divorce proceedings and represented juror number one's wife, and he therefore lied. He therefore lied in checking that he did not know her. So, let's get it on again. Certificate of service. It was all this was served. Let's get to the exhibit. This is fun. This shows you why you don't want to piss off lawyers. There's a lot packed into this. There's a lot packed into this. Comes now Deborah M. Salisbury, upon her personal knowledge, oath, affirmation, and deposes and says as follows. Upon her personal knowledge, her oath. This is sworn again. Don't forget that. I have been duly licensed to practice law in the state of Florida since April of 1993. That's like over 35 years. No, 30. That's 30 years, isn't it? Me do math. It's like almost 31 years. Just a couple more than me. So that's been a long ass time. Affian has continuously remained a member of the Florida bar in good standing for more than 30 years. Despite practicing in a difficult and confrontational area of law, I stand on my reputation as an officer of the court as to these circumstances. That's a powerful statement right there. She's saying, look, I'm putting my name on this. I'm standing by my reputation as a 30-year officer of this court, practicing in good standing in some really awful conditions, that what I'm saying is the absolute truth. That's a powerful first sentence, paragraph, I guess. I've been board certified in juvenile dependency law since 2018. As the court may recall, I represented Jack Kowalski and at times the decedent Beata Kowalski in the underlying shelter and dependency action brought by Department of Family Service 2016-17. I've been deposed in the present case. So she is involved in this case after all this stuff happened. So what we're focusing on here is what happened before 2016. What happened before all this went down? Did he know her from a previous experience? Did he know her from representing his wife? Well, let's find out, shall we? On Friday, December 15th, I was present in the gallery in courtroom 2B of the South Sarasota County Courthouse when this matter was before this honorable court for oral argument on issues involving claims of misconduct by the then so-called juror number one and his wife, Yolanda. At that date and time and place, defense attorney Ethan Shapiro represented to this court, that means testified to the court, that means gave his statement as an officer of the court to the judge, that the undersigned attorney had represented juror number one's wife in her prior divorce case. As an officer of this court, I bring this misrepresentation of the record to the court's attention. Misrepresentation is a collegial lawyerly way of saying lies. As an officer of this court, I bring these lies of the record to the court's attention. I herein state to the fullest extent of my knowledge of juror number 1 and or his wife prior to being in this courtroom and learning what I take to be an attack by the defense on my personal integrity, personally, as an attorney, based upon allegations as to juror number 1. Damn, she's coming out swinging already in the 5th paragraph. She's saying, I take this lie by the defense team as an attack on my professional integrity, an attack on me personally, an attack on me as an attorney, and I'm here to defend those things. I'm here to defend my integrity, defend myself personally, and to defend myself as an attorney. Defense counsel erroneously and intentionally that means he meant to lie. It wasn't a misstatement. It wasn't a misunderstanding. It was a lie. Defense counsel erroneously lied that I was involved in some wrongdoing via some prior knowledge or involvement, which never happened. During 2007, I was court-appointed counsel to represent another individual involved in a family court case numbered, given the confidentiality rules. So she was involved in something back in the day, but because there's rules of confidentiality, she can't say who it was or how she represented them. She was involved, but so I am prohibited from identifying my client. But per the above, Yolanda Phelps attended a brief hearing, and although I may have seen her, she was represented by other counsel, and I in no way represented her. In this context, Mr. Phelps, as a petitioner, was more or less in opposition to my role. Ms. Phelps, as a petitioner, was more or less in opposition to my role. She was more or less on the other side, so I probably wasn't representing her. To represent in any fashion that I was counsel to Ms. Phelps or her current husband, Paul Lingle, now, unfortunately for him, reduced to being juror number 1, is a misrepresentation. Again, read misrepresentation as lie. It is a lie. Whether I was is an attorney of record. Bad writing there. Whether I was is an attorney of record in Ms. Phelps' divorce case is an objective fact easily confirmed from the divorce case docket. Easily confirmed by what does that mean? That means another officer of the court, Shapiro, anybody else on the defense team and anybody else out there in goofy fucking Reddit land, all they have to do is go to that case number that's designated, look at the parties, and look at the lawyers who represented them. It's that easy. These lawyers do this every day. Oh, who's opposing counsel in this case? They look on the court record, they look on the doc, and they go, aha, that's the opposing counsel. All they had to do, she's saying, is go and look at that, and it was the easiest thing they possibly could have done. All they had to do was go and look at that divorce case docket, and they would know that I was never counsel to anyone involved in the present case, least of all juror number 1 or his present wife. That's a double-barrel shotgun right to Shapiro's grill, right across the bar. All Shapiro had to do was just go and check this stupid little fact. Just go on the damn court site. Bring up that case number. See who's the attorneys of record. He didn't do that. And he lied. Or he did do it and absolutely lied. I respectfully request that this court acknowledge in any orders issued out of this circumstance that I have completed my duties as an officer of the court by notifying the court of this intentional misrepresentation by defense counsel. There's a little ethical thing for you. If you know that another lawyer is demonstrably, clearly lying to a judge, if you know that a lawyer is telling a lie to the court, you have an affirmative duty to rat that lawyer out. If you know what's going on and you don't rat them out, you can be facing ethical violations. So she's saying, I knew what he was saying about me was a lie. Therefore, I have an affirmative duty to go rat his ass out. And that's what I've done in this affidavit. And now, Judge, I want you to put on the record that I did my job ratting him out. I respectfully request that this court acknowledge in any orders issued out of this circumstance that I have completed my duties as an officer of the court by notifying the court of this intentional misrepresentation by defense counsel. if any effort to review the divorce case docket had been undertaken, let alone contacting me, as I would hope counsel would do, if nothing more than as a common courtesy. So she's going in hard on this again. He not only could he have looked at the goddamn record, he could have called me, picked up the phone. Her number's going to be there on every bar has a confidential bar list with all the other lawyers and their telephone numbers and stuff like that. All he had to do was go there into the bar site and pull up her phone number and call her, or look in the freaking yellow pages, or do they still have them yellow page things? Probably don't have yellow pages anymore. I'm old. Looked up somewhere in Google and found her. But nope, defense counsel could have easily confirmed that the undersigned attorney was never counsel to, nor the attorney of record, or in any way the legal representative of juror number 1's wife, previously known as Yolanda Phelps, in a divorce case. Any review of the record or even that trial docket will show that neither party was represented by counsel. This fact could not be any clearer. Suck it, Shapiro, is what that says. Read between those lines. The undersigned counsel has never represented juror number 1's wife or juror number 1 in any capacity whatsoever at any time. Based on my best memory, the undersigned counsel has never even met juror number 1. Further, I have never met juror number 1, Paul Lengel's wife, Yolanda Lengel, other than as indicated herein. Further, affiant saith not. Further, affiant saith not is the standard legal way of saying, I ain't got nothing else to say. This is a dynamite affidavit. This is her just calling him out several ways, a bald-faced, intentional liar, to the point that it was her duty as an officer of the court to affirmatively approach the judge and give this affidavit saying this shit never happened. And I want you to tell everybody that I was the one that put this on the record because that's my duty to do so. Boom. This is an absolute suck it to Shapiro. And speaking of people that enjoy saying suck it to Shapiro, it's Megan Fox.
Hi. Good morning. I've been enjoying listening to this.
Ooh,
What a
I broke a
savage
sweat.
affidavit.
I broke a sweat reading that one. I'm feisty today.
I love it. But, I do have to say, there's a reason why he didn't pick up the phone and call her. You know what that is, right?
You say no.
He's spreading calumny. Because the whole point of this, the whole point of of these attacks on the juror was to intimidate and to defame. And so he didn't pick up the phone because he didn't want to hear, no, you're not right. He just wanted to put it out there and ask for forgiveness later so that Reddit would do his work for him and spread all the nonsense, which they have done, and defame juror number 1 even more.
But there's the problem. You don't get to lie to the judge.
You do this one, though. He lets it happen. You think sanctions are coming? I don't think
so.
That's
the next motion we're going to look at.
All right.
That's the next motion we're going to look at. But first, welcome, Megan Fox.
Hi.
I know I told you we had a lot to go through. Yeah, sure. I know I said we had a lot of stuff to get through here. We got to keep focused. I know I said that, but, hey. I'm
going to be very quiet.
It's Megan Fox, everybody. Let the chips fall where they may. Give it a whirl.
I told everybody yesterday, I said, Jeff's doing this tomorrow. Maybe he'll have me on. I don't know. Maybe he will. If he wants me, Jeff's maybe one of the only guys on LawTube who can control me. So
it's because clearly others can't. Just say it.
Clearly.
I have a way with it.
Yes,
all right.
Women. It's true.
Oh my God. I have to close my Twitter. I can't look at that former Harvard president staring at me in the face while I'm
You mean the gay that's out at Harvard? That was the weirdest headline I ever saw.
Well, it was
gay
from
out at Harvard.
It was from the Drudge Report, so it had to be that way.
I love
gay
that Flux responded, a gay out? That sounds fun.
Yeah. What did Flux say? Oh, sounds fun. What's a gay out? We love Flux.
Flux kills me.
Whew. Jeff has medium control.
Well, whatever it takes.
Wow. I I just broke a sweat reading that thing. I was impassioned. That stirred me. That stirred the heart of the Lorax.
It was a really good affidavit. Yeah.
And your son has the cutest Lorax
mustache. Yes. I gotta send you a picture of that, of him wearing it. It's a crack up.
That's funny. Well, speaking of things that aren't funny, we have nope. We do have all of the super chats and everything read already. So let me just unstar these.
Whose butt am I looking at? I'm not used to the dogs being here so quickly.
Yeah, I found the way to lure them in. I have a little space heater that I put there, and they just lay in front of the space heater.
I like how
hey,
is that Yoda
joined in?
Is that Yoda giving his butt to the camera, or is
no?
That
that's Strawberry.
I can never tell. Oh, Strawberry has more brown.
Yeah, okay. Strawberry's the brown one. Yoda's the one that's just laying there looking dumb.
And Strawberry's licking the floor.
Yep.
These dogs are less than medium smart, but we love them.
Could be licking windows, but that'd be a step up. All right. Wow. Megan Fox. We have a motion to strike and motions for sanctions.
Yes.
Yes, that is a guitar case. That is one of the guitars that are scattered about the house. Let's see.
I didn't know you played, but I should have known that because you're raised Mormon. Don't all Mormons have to play instruments?
What?
Is that a thing?
It's not a thing.
It's not? I don't know. I saw
No.
this Instagram post the other day of this Mormon family, this huge Mormon family, and they were all playing string instruments.
Well, I think that was that's like a holdover from the Osmonds, the Jets from the 80s.
Your family didn't have a band? I thought all Mormon families had a band. Everything I know about Mormons I learned from the Osmonds. Oh.
All right. Plaintiff's motion to strike and motion for sanctions. All these people are coming here and asking for this. Hereby move to strike defendants filing for the subpoena for juror interview in violation of court's December 20. Oh, what? The defense have violated a court order? The hell you say? What? So they're saying, look, they pulled some shit, and now we just want this whole thing thrown out. We don't even want you to bring in juror number 1 for question because of what they've been doing. Let's see what it is. And of course, clearly he's going to be questioned here in a few hours. So the judge denied this one. Right. What is this court's decision? What is this violation of the court's order that they did? The court directed the defendant to redact any and all identifying information, including the physical location of juror number 1. You'll all remember their first post-trial motion, which they're always supposed to attach it to the back, not put it anywhere in the document, put it as like an appendix or an attachment or even in a separate document. But no, they put it in the footnote of page fucking 1. And the judge says, don't ever, 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 ever do that again.
Too late, too. It was way too late.
Yeah. The court directed the defendant to redact any and all identifying information, including the physical location of juror number 1. Well, defendant filed his subpoena with the GPS coordinates unredacted.
You got to ask yourself, is this a mistake at this point, or are they doing this on purpose?
In case you didn't know his address from page 1 of the first document, here's his fucking GPS location.
Tell me how you feel about it, Jeff.
My Lord.
You're getting awfully red.
Holy Jesus. What is that? What the fuck is that?
The pattern of the defense counsel's conduct in this regard is now prolific. It's palpably prolific here. Sorry.
Oh my God, I almost ruined my microphone.
Sorry.
But what's worse is that I was thinking the word palpable as soon as you said prolific, and then you said it.
I know you were. That's why I said it. We're not going to get through. We're not going to get through. We're not going to get through.
Shh, I'm gonna
we're not going to get through 70 pages of motions here. I'm sorry. This is not happening.
Yes, we are.
All right. It's now prolific and intentional, having repeatedly made the personal information of juror number 1 public record in this case. Wherefore, plaintiffs move for an order striking the filing date of December 26, 2023, and for sanctions and for other further relief this court deems just and proper. So, there you go. Coming for blood. But, well, all good things must come to an end. Now I've got 30 pages of the defense telling us why they need to expand this, because I'm just going to telegraph this here from what I see and what I understand. The judge here's my premonition. Here's my what was the great Karnak? That was the Johnny Carson character, wasn't it?
Yep, the great Karnak.
The great Karnak, or Dave Chappelle's Negro Damas.
Here, an envelope.
Yeah. Yeah. I should have worn my purple silk shirt. Then I could have been Paul Mooney's Negro Damas. Here's what's going to happen as I predict. And the first reason why I think I might be right is because the judge has scheduled this for 3 p.m., which means he ain't going to be there much past 3 p.m.
No.
I foresee about 5 questions. Do you know this person? Did you do this? Did you talk to anybody else? Are you besties? And did you and your wife talk about the trial every night? Okay, out you go. Shapiro, off you fuck. Done.
Oh, I didn't even think about that. The timing of it. Yeah, why 3 p.m.? That's a very good point, Jeff. Strawberry's repositioning her butt so it's more in line with the camera.
because we're about to read Shapiro's motion.
By the way, there's about 4 pages in here you can skip because they're just repeats of shit we already read. So I'll tell you when we get there.
You have lovely hair today, Megan. Let's talk about it until Jeff's likes are at a good number. My likes are always at a good number.
Are you sure? Did you guys hit the like button? Because if you didn't hit the like button, you are going to have to hear about my hair.
We've got 900 people here and 446 likes. That's 446 likes. It's still like half of the people. Just get down there and do it.
That's not enough. That's not enough.
It's still 450.
Don't make me tell you about my hair care routine.
Oh, sweet Jesus. Let's get back onto track here. Just hit the like button or she'll continue. Just make it stop. Make her stop. All right. This is the defense explaining why they need to not only expand the questions, they need to be able to ask the questions, and they just absolutely must have Mrs. Juror number 1 present to ask her questions too. No, Megan, I'm not reading that. Motion for reconsideration of scope of juror interview. Defendants, Johns Hopkins, defendant. Oh yeah, we have to say it, defendant. Johns Hopkins All Children's Hospital, Inc. Inc. is Inc. Let's not forget, they're a big fucking corporation. By and through its counsel, blah, blah, blah. Okay, an order granting a limited interview of juror number 1. The scope of juror number 1's interview must be expanded because there's more than one reason. 1, defendant's supplemental evidence of juror misconduct, including juror number 1's materially false statements on his jury form, which we've just read about, is timely and requires inquiry. 2, the interview's current scope would inadequately investigate the potential misconduct. And 3, defendant has learned of additional improper communications between juror number 1's wife, plaintiff's counsel, and the jurors. See, it's italicized. That means now she's being accused of talking to other jurors, not just her husband. But again, as you'll find out, spoiler alert, it's all after the trial, so it doesn't really mean shit. That require additional inquiry. Although the prospect of starting over with a new trial is understandably frustrating, this court cannot and must not sacrifice the integrity of the jury process in the name of expediency.
Hilarious, him using the word integrity.
Yes. Cannot and must not sacrifice the integrity of my bullshit, automatically lying statements that I put in. Oh my God. All right. Facts and procedural history relating to juror number 1. Yeah, I don't think we need to read through this. It's just to strike for cause. Need a preemptory challenge to strike him. They were just getting ready to strike him, and then then Anderson said, "Oh my gosh, I need to talk to my client." And the client said, "Oh wait a minute, we've got him in the bag here. You know, my wife is talking with everybody, and we're doing all this shit. So we need him on the jury for God's sake." And so then you go, "Oh, never mind, we can't dismiss him. We need this guy on there." This is the shit that's going on in Reddit and Shapiro's like brain. What? Are you okay, Megan?
Yes. I'm just laughing. It's funny. It is. You're right. You're right on. That's exactly what's happening.
Yeah.
Reddit is melting down, by the way.
Oh, I fucking hope so.
They're threatening to dox. They're threatening to dox me.
Oh. Yeah.
Aren't they? They're really quality people.
Before jury deliberations began, defendant moved to disqualify juror number 1. Defendant was unaware of juror number 1's wife's pro-plaintiff online activity. Doesn't fucking matter. She's not on the jury. Of course, had defendant been aware of these facts, it would have alerted the court in its motion. Maybe your wife, who was doing the same fucking thing for you, should have looked for other stuff. Just saying. Then we had the hearing, and then, speaking with his client, plaintiff's counsel returned to the bench and told the court that Mr. Kowalski feels more comfortable with juror number 1. Motion to disqualify 15 days of the jury's $250 million verdict. See, and this was a stupid thing to say. He was trying to shock the judge with they gave a $250 million judgment. It's not going to work on the judge because the judge just a week or so ago said they could have asked for $500 billion. They still would have been able to cover it. So the judge is not going to be impressed by that line.
They love saying $250 million. They think that it shocks people. But they don't know we've been living through Joe Biden's inflation for a while. So $250 million is like, it's like what, 4 trips to the grocery store now?
That's like 5 days of support to Ukraine. Weird. Anyway. Within 5 days of the $250 million verdict in plaintiff's favor, defendant moved for a trial on several issues, including the misconduct of juror number 1. Detailed extensive information learned about juror number 1 and his wifey, including that during trial, juror number 1's wife sought out and sought out and befriended a woman named Jules. Hey, everybody in chat, say hi to the woman named Jules. She's here with us right now. That'd be that'd be a great Western movie. Like you have like some Slim Whitman soundtrack or some Marty Robbins playing The Woman Named Jules as Clint Eastwood rides his horse through the desert in a spaghetti Western. That'd be awesome. Right about like High Plains Drifter, How the West Was Won, A Woman Named Jules. All the great Westerns. An outspoken plaintiff's advocate who, according to her social media posts, communicated regularly with the Kowalskis and advocated for them in person and online. So what? Where does juror number 1 fit into this? Jules, oh good Lord.
Poor Jules.
I know.
Oh no, now there's butt sniffing. What's
wow!
Aw, butt to butt. How cute are they?
Dancing cheek to cheek.
Right. Oh, so cute.
I was an advocate for myself. Thank you very much. But juror number 1, Jules, juror number 1. Oh, for fuck's sake. All right, let's get on with this. Juror number 1's wife shared her personal contact information with Jules. Exchanged messages with her. Blah, blah, blah. Jules. Okay, there we go. Relevant information. Well, how about, relevant information would be nice. How about some relevant information? Generated by members of the public? Megan?
Yeah.
What's another word for general members of the public that the defense like to use?
Oh, the bus stop.
Bus stop people. Yes. The bus stop people he hates. They're only bus stop people, and he only hates them if they're like not saying what he wants them to say.
Uh-huh. Right.
He doesn't care if the bus stop people, they're the limousine people if they're helping him. They're not,
He only likes the members of the public who are pro-hospital. The rest of them are just redneck hillbilly bus stop people.
It's happening with Harper. Oh my God, someone met someone in a courtroom. Exactly. Greta Thunberg's voice. Oh, we can do better than Greta Thunberg's. Oh, see, oh my God, I need to have this locked and loaded.
How dare you?
That's good.
Yeah. How dare you? All right. Wait, you ruined that shot. That was a perfect angle. Yoda was just finally joining her and expressing opinion of the motion. Yeah, well. Resume floor licking. All right.
Where did Yoda go? Yoda was cuddling up.
Yeah, Yoda just wanders off. He's a bus stop dog. He just wanders off.
There's just no counting for Yoda.
There's not. The extraordinary public attention on this case continues to generate highly relevant evidence. Evidence, not information, evidence. Besides broad media coverage, the case has internet superfans across the globe who spend hours each day not only watching the trial online and discussing it in chat rooms, but also searching publicly available documents. Well, there was a fucking publicly available document for you to check and see if this woman was representing either one of these two, wasn't there? Where the fuck is your army for that? Where's your army for that, Shapiro? There's an army of your little fucking worker ants out there looking for shit, and none of them looked at this? You didn't look at this?
I feel called out, though, by this superfans thing. I feel very called out and judged. Don't judge my hobbies. So what if I like to pore over legal documents?
Yeah.
Fuck off, Shapiro.
Many, like, quote, Jules, if that's your real name, are pro-plaintiff, while others believe that the hospital has been treated unfairly. Unfair. A number of these superfans have apparently reached out to counsel on both sides. The court, understandably wanting to affirm that the parties' counsel are not deputizing an internet community to do indirectly that which an attorney is expressly prohibited to do directly. It's kind of what your wife was doing, though, wasn't it? Just saying. Hey, everybody, look for this. Help me find this. As pointed out there, conduct, whatever. We'll have to look at this rule of conduct if it ever comes up. But this is the judge's interpretation, I guess, which prohibits attorneys from initiating direct or indirect post-trial communication with jurors. Okay, that's what it is. They're not allowed. So the lawyers can't contact the jurors and ask what happened. So they're sending their minions out to do the work. You say, no, we can't do that. That would be wrong. Oh, unless you happen to be for the other side or us. Anyway, never mind.
There is a strange thing with that rule, by the way, because I did look it up this morning. I didn't see anything in it that technically Shapiro really broke, because it only says you can't directly or indirectly contact a juror. It doesn't say you can't use people online to dig up shit on a juror. So it's possible he didn't break it.
But see, that's the unethical part here, where the court deputizing an internet community to do indirectly that which an attorney is expressly prohibited to do directly. That's a bad thing.
But he could, but there's nothing stopping Shapiro from investigating juror number one. That's allowed. So if he deputizes the internet community to do that for him, he would be allowed to do it. So he can do that too, I think.
Well, they're saying he can't reach out and say, do this on my behalf. But if someone brings them information, they can accept it, which is what he's saying here. To be clear, no one on defendant's team. Then he did violate it, because he did reach out, and you'll see that in the judge's order. So, okay. No one on defendant's team has initiated contact with these helpful members of the public.
Oh, bullshit.
What was your wife doing?
No, and he did it too.
Yeah. He posted that little we love you and thank you thing. Yeah. Keep up the good work kind of shit.
Yeah, keep posting, keep giving us stuff. We're looking at it, we're using it. It's going into emotion. My chat found posts on Reddit after that said they believed they had been hired by him. They were like part of the team.
You Reddit people are fucking stupid.
I know.
Just say. And if you're offended by what I just said, that means I'm talking to you.
They use screen names like Shapiro Lover. That is not a joke. Somebody on that Reddit page, their screen name is Shapiro Lover.
And it wasn't his wife? Dun, dun, dun.
It might be.
Right. So we never did this or asked anyone to take any action that the attorneys could not ethically or legally take themselves. Members of the defense team have, however, received unsolicited communications from members of the public. In addition to unsolicited threats and insults.
I want to see those.
Have you looked at the shit that the plaintiffs have been getting, for God's sake? From your fucking minions, you idiot. Insults, threats and insults. Members of the defense team have received unsolicited and highly relevant information discovered by members of the public who studied the trial. The ones who was just in the paragraph before. Anyway, the usual dynamic of this case does not make information any less relevant than if it had been discovered by the attorneys themselves, nor is the information untimely or waived if produced as soon as practicable in advance of the ruling on the post-trial motion. If it is relevant and substantiated, it must be considered. The extraordinary public interest in this case has prompted 3 defense supplements. This is where we get to go over all the stuff that was talked about before. Defendant learned that juror number 1 was accused by a former spouse of domestic violence and child abuse, which is like this is just fucking. He did it again when the judge specifically sort of gave him a mild reprimand for bringing up something that was over 20 years earlier. He's specified exactly what happened here. Given the circumstances of this case, where both sides have been accused of child abuse, juror number 1 was obligated to disclose that incident on the supplemental jury questionnaire. I just feel dirty just even reading that fucking paragraph.
I know,
but it's out there.
It's awful.
Hey, bus stop. The hearing is at 3 p.m. Eastern today.
I'll be covering it on my channel. I'll be live.
Wow, Examoon. I'm not reading that, but that's funny. Defendant's first supplement also appointed to juror number 1.
What did I miss? God.
Yeah, exactly.
That Clark Kent's maybe.
No, and including a post where he intimates that defendant's counsel and JHACH are immoral and evil.
If the shoe fits, that's what I say. I don't know. That's a perfectly protected opinion under the First Amendment. Putting it in a motion to complain to the judge that, oh my God, this juror who voted against us thinks we're immoral and evil. Isn't that why you take people to court, Jeff? To see if the jury believes that the people you just took to court are as immoral and evil as you think they are?
And that's why you rule against them. That's why you bring back a verdict against them. Megan doesn't need buttons today. She has Jeff.
I'm trying not to piss off Jeff.
The highlighted words are the important words in this whole thing. Post-verdict posting. He can say whatever the flying F he wants after the verdict. He can call him as immoral and as evil as he wants after the verdict. Oh, then the inexplicable use of SS insignia for Sally Smith. Pre-verdict bias came to the defendant's attention before the December 15th. So the pre-verdict bias came to the defendant's attention at post-verdict when people just started trying really, really hard
to find a conspiracy.
Leading to the second motion, in which he inexplicably drew the S's in Sally Smith's name markedly different than every other S in that note and all previous notes. Ooh, right here, the Kiss Army, or as Sally Smith. All lightning
still
bolts.
Rehashing this.
Given the similarity of the S's to Nazi SS lightning bolts, and in
How
light
do you
of
think the judge is reacting reading this? Like, I already ruled against this shit.
He's like, don't make me bring out the old guy with the Kiss album again. And of all the Kiss albums, that was like one of the worst. Anyway, given the similarity of the S's to Nazi SS lightning bolts, and in light of juror number 1's post-verdict calling Hatch evil and tyrannical, notice how tyrannical isn't in parentheses, like it almost never was exactly that word.
Yeah. Oh, that's interesting.
Yeah.
So making shit up now.
Defendant believed that juror number 1 was analogizing Sally Smith to Nazis in the middle of the trial after repeatedly instructed not to form an opinion until after receiving all evidence. Third supplement, RE undisclosed 2016 criminal threats and protective custody order in Charlotte County. A few days after the December 15th ruling, defendant learned of yet another material misstatement of juror number 1 made on the jury form. Defendant provided information to the court in the hearing that subsequently filed a third supplement to the jury's number 1 motion. On juror questionnaire, juror number 1 said that neither he nor any member of his immediate family had ever been the victim of a crime. Well, it turns out that juror number 1 and his wife called the police and reported that juror number 1's son had reportedly threatened to kill them. As far as I know, that was never adjudicated. There was never a declaration that a crime had occurred. It was an allegation. It was an assertion. So, yeah. Juror 1 applied for and received an injunction for protection against, still, that's not a conviction.
No, it's not.
It's not a crime until a jury says it's a crime, or they admit to it. Attached to juror number 1's petition for the injunction was an 11-page document detailing juror number 1's stepson's criminal history, his threats against juror number. So fucking what? I'm not even going to read that shit. Okay. Juror number 1's stepson pleaded nolo contendere, that's like no contest. He pleads no contest, which is essentially a guilty. But, okay, ask him, all right, sorry, did you forget about that? Yeah, I forgot about it. Okay. And I don't know if you'd even consider that a crime. Like, yeah, who knows? Okay, so it wasn't nolo contendere. Sorry, my bad. Anyway,
Well,
yeah.
if you plead no contest, what is that a guilty plea or is that a
Essentially, it's you're just saying I throw in the towel because even though I'm not admitting guilt, you have enough evidence to convict me.
well? So
it's treated as a guilty. No, it's technically a guilty.
Also, it's also possible that he doesn't consider himself a victim of a crime,
Yes, exactly.
especially if it's a family matter.
Yeah,
That's not
exactly.
exactly something that's going to pop up in your head and be like, oh yeah, I was a victim of this crime perpetrated by my stepson. Family
Paul Young Esquire,
dynamics
yes,
are-
same as guilty. Yeah, essentially, it's a nicer way of pleading guilty. It's
Okay.
like I'm not admitting to it, but if it goes to trial, you got enough to get me on it. So
Yeah.
I'll just wave the white flag now. Yeah, and as Mathis says, as soon as it pulls up here, here we go. Yeah, he disclosed that his stepson was charged. He just didn't consider himself a victim because there was only ever a threat of violence.
Right.
There could be any
There's a
number of
lot of
explanations.
explanations.
Yeah, exactly.
I mean, I think it was Hayden who was saying that going back over time, you may be a victim of a crime that you don't even really remember,
Yeah.
And we're talking 20 years ago too. This was not a material mistake.
This was 2016.
Oh, this one was
this-
2016. What was
Yeah.
what was 20 years ago? Oh, the
That was-
divorce thing.
Yeah, that was the
Okay.
the abuse allegation. Well, anywho, court ordered limited interview. So then the court says, all right, we'll give you an interview. The court further ruled that the interview's juror would be limited to 4 topics. And I think these are, 4 topics. They're okay. I guessed 5 questions. There might only be 4 questions asked. Whether juror number 1 received or shared information about the subject matter of the trial through outside sources, including a spouse. And I can see the judge saying exactly that. Did you receive or share information about the subject matter of the trial through outside sources, including your wife? No. Okay, then he moves on to question 2. Whether conducted an investigation about the subject matter of the trial. Whether juror number 1's knowledge of Deborah Salisbury, if any, what was the knowledge of Deborah Salisbury, if any, when he completed the questionnaire? None. Okay, move on to question 4. Whether juror number 1 has an undisclosed opinion about DCF or any other entity to what extent juror number 1 and DCF or any other entity were involved in the domestic violence case described in defendant's first supplement to the motion. And I literally think those might be the only 4 questions that the judge asked. Maybe a couple of qualifiers or clarifiers. But I think that's probably going to be about it. Unless, dun, 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 this motion gets passed, but it doesn't.
I feel really bad for the stepson, to tell you the truth. I think he's gotten the worst end of this, besides juror number 1 and his wife, like the whole family. Like, who needs that dug up and put all over the internet? Who knows what kind of mental health issues are there or whatever. I just feel really bad about all of it. I get sick when I read this. Assholes.
I love this paragraph. The court also expressed concern that the counsel was deputizing an internet community to do indirectly that which attorney is expressly prohibited to do. And that's exactly what the judge said. I'm concerned that you're doing this, which prohibits attorneys from initiating direct or indirect post-trial communication with jurors, as will be sworn to in forthcoming affidavits. None of defendants' counsels have ever initiated communication with jurors directly or indirectly. Okay, see, that's not, see, notice what we've got here. Deputizing an internet community to do indirectly that which the attorney can't do, and talking about contacting jurors directly. There's a lot of unethical things that the internet community can do if they're doing it on behalf of the lawyers. But as will be sworn, so they're like, we haven't initiated contact with jurors directly or indirectly, and we haven't encouraged or solicited members of the public to do so either. Yeah. Plaintiffs apparently cannot make the same representation.
How do they know that? I think they can.
Well, because defendant has learned that post-trial a note was delivered from juror number one's wife to the jurors and alternate jurors. This is after trial. And there's nothing to show that this was done for or on behalf of the counsels, for and on behalf of the plaintiff's lawyers. Juror number one's wife provided Nick Whitney, the plaintiff's lawyer, cell phone number and delivering message from Nick Whitney to the jurors. The note, okay, we'll see about this message a little bit. The note also contained juror number one's wife's contact information, Jack Kowalski's contact information, a list of YouTube commentators that followed the trial, and a final admonition from Nick Whitney advising that as the case is on appeal, be careful what is said to the media. An image of the redacted letter appears below. Nick Whitney, please express our overwhelming gratitude for having delivered justice for Maya Beata. So, all of the jurors fulfilled their solemn duty and we're forever in their debt. And if you're all lawyering up, here's the contact number. If you want to talk to them, which, any of these lawyers that doesn't, any of these jurors that does not have a lawyer at this point, I would be surprised.
Y'all need to get some lawyers quick.
Even if it's just as much as I was on that jury, please stand by.
Think about this, though. How sick is it? I didn't even think about this. That they all have to get lawyers. They have to retain lawyers. They have to pay for lawyers.
Yep.
Who's going to pay them back for that? I think JHACH should have to pay for every single juror to have an attorney now because they're the ones attacking them. Why should the jurors, who through no fault of their own, get pulled into this bullshit where they make $20 a day and now they have to get lawyers? Terrible.
Scarlett Sullivan says, am I the only one that's kind of annoyed at juror number one's wife? I know it's her right, but was this really necessary? I mean, in retrospect, I doubt she would do it again if she if she knows what she knew today.
But after listening to Peter Tragos talk about his experience with jurors, I actually think this is totally normal. So he said it's absolutely normal for juries to get together afterwards, to share information, to talk to one another about the case, to go out to dinner. Nothing she did here is unusual at all. So
some of the O.J. Simpson jurors are still friends.
Some jurors
they lived
books.
in a fucking hotel room together for 9 months.
Right. And some jurors write books about their experience when they're on these high profile cases. And it's interesting, right? Wouldn't you want to hear what juror number one's story is after all this? I mean, they've made this guy, I hope he does write a book. Take the gift when it's given and run with it. They should profit off it somehow.
J-hatching needs to become a verb. They're J-hatching again.
Yeah. J-hatching. That's funny.
Stop. Chat, stop thinking of movies naming with Jules in it.
I can't stop myself. I was doing it too. I can't stop. It's funny.
Romancing the, come on, Jules. Anyway,
Jules Academy, Jules Gump.
Oh, that's mean.
It's funny. We're just putting our name into different movie titles.
Yeah, the Scott Peterson jurors wrote a book, and they're still friends to this day. When you're involved in something like this that goes on for such a long time, yeah, you have this common thing Star Trek II: The Wrath of Jules.
That's a great one. The Wrath of Jules.
Damn it. I'm so sorry, Jules. I did not mean to start that. Oh, Lordy.
I think she's enjoying it. She's been laughing.
Oh, that's good. I have enough enemies. I don't need a plaintiff's advocate and internet goon squad run by Jules on my case.
Jules Rassick Park.
Wow. All right.
Sorry.
Rain Man YYC. Member for 8 months. Thank you so much for your support for such a long time. They're trying to provoke the judge into an angry outburst to support their appellate slander against them. Oh, you're giving them way too much credit. No, a lawyer never wants to lose intentionally because appeals are for losers. You don't want to do anything to make your position worse than it already is. I don't think that's happening at all. And thank you, Nicholas Starrow's Trial Watch with the 50 sexy monies. Thank you so much. You have lovely hair today, Megan. We talked about that earlier. Let's talk about it until Jeff's likes. Our likes better be a good number. Oh, we are. We're at 1,175 concurrent viewers. God knows what you people are still doing here, hanging around. But thank you for being here as we go through this. And there's 700 likes. So like 500 of you at this point haven't done your deal. So get out. Oh, this is a good point to bring up our poll of the day, which I had a really great poll, and I apparently didn't save it. I didn't have time, and I couldn't remember what it was. So we just threw up the hit the poll here. Like and subscribe and follow our poll. Vote on the poll. JHACH defense, dumb, 4%. 5% of you say dumber. 60% of you say dumbest.
I love the poll today.
And 31% of you say childish poll, but they are stupid. So that was just like a literal last second effort when I realized that my original, very well thought out poll had apparently just gone away into the ether somewhere. Reservoir Jules. Stop, Jules Fiction. Stop. Oh my God. All right.
Reservoir Jules.
I like it. David Woodmansey, Judge to Shapiro. I don't think that word means what you think it means. Exactly. The Princess Jules. I think it's already been said, though. Cheesehead lost on Bourbon Street. Remember, for 16 months. Oh my God, that's like literally you're one of our first members. God, it's been a long time. Cheesehead's lost on Bourbon Street. Remember, for 16 months. Why do they care what juror number one's wife thinks? Couples vote for opposite people and for president and cancel each other out. Husbands never do what their wives ask. And you know what? Husbands almost never ask their wives what they're doing, and they don't care even if the wife offers the information.
Yep. That is truth. Facts.
Does your husband have any idea what you watch on television?
No, he also has no idea what I do online. None.
Yeah.
Zero. If you asked him what social media does your wife use the most, he'd be like, not Instagram, because she never replies to my reels. Like, that would be the only thing. He uses Instagram and I use Twitter. He's never on Twitter. I'm never on Instagram. He would have no clue what I do.
Well, the question is, why do they care what juror one's wife thinks? Because in their world, their logic is juror number one's wife does X. They live together, so therefore there is unquestionably no doubt in our minds that they were talking about this case from the jump. With zero
fantasy
evidence
built up in their heads, and they just will not let it go. I'm not even sure if they believe it at this point. I think this is all just desperation.
I'm with you. Tara Rayner, Jules in Best Mariah Carey. Why are you so obsessed with me? Nice. That's good. Thank you so much for the super chat. And Matt Bond, thank you so much for your support as well. For the record, on the record, let the record show. Good. Read the. It stopped. Tara Rayner again. If you don't want to be compared to a Yahtzee, don't be one. Yeah, there you go. Words to live by. Tara Rayner. Thank you so much for your additional support. And Jennifer with a $5 super chat. Thank you. £5 super chat. My bad. Thank you very much. If we are bus stop people, does that make Ben Shapiro's Redditors bus stop lickers? That's unhygienic. And LA, our newest member. Thank you so much, LA, for being the newest member of the Clean and Sober crew. Thank you very much. All right, let's get into the argument here. We've got a bit of ground to cover still, and we're halfway through, and I'm sweating like a hog in the summer. I'm animated. this was the wrong
My
thing to
locals
wear.
chat. My locals chat wants you to attach a heart rate monitor to you that you can put up on the screen. They think that would be fun watching you get, because you're very worked up today. Everyone wants to know what your heart rate is.
It's slightly elevated.
Slightly elevated.
I should have done that. That'd be funny. The totality of the circumstances here compels a meaningful and much broader investigation to uphold the integrity of the jury process and the right to a fair trial. The evidence of misconduct raised in defendant's supplement to the motion relating to juror number 1 is not waived and must be addressed in the interview. Further, additional questions listed below in section B should be put to juror number 1 to adequately investigate the allegations of juror misconduct. Finally, juror number 1's wife and plaintiff's counsel. They want to put Anderson on the stand. Oh, yeah. Like, good fucking luck with that, which, of course, we know none of the shit's happening. But, yeah, they actually wanted to put Anderson on the stand and asked under oath about the post-trial note. Oh, they want to put Whitney on the stand. Delivered to the jurors and alternate jurors.
Who don't they want to put on the stand?
Everybody.
I'm starting to get concerned about that list of people mentioned in the letter. They're going to want to put us on the stand next.
Well, luckily you survived the you survived the YouTubing. You weren't mentioned. Much to your shame.
I was in
Oh yeah, well yeah,
you
were in that one. Yeah.
Twice now. They had my Twitter account first, and now they've got me on this letter from the juror number 1's wife. I am a little frustrated by it.
You were on this letter?
Yeah, you didn't.
Oh, Megan Fox, look at that.
Yeah, and you know.
Come on, juror number 1's wife. You've been in my chat. Why wasn't I in the list? Come on.
Why isn't Jeff on the list?
I'm feeling left out now.
But I have to tell you, this repeated alerting them to our little community here, our interests, it's upsetting because we've got some litigious, nasty ass lawyers with a big budget who want to make people's lives hell. And I don't like being in their.
Cannot lie. No other lawyers can deny.
I don't like being in their motions. Tell you what. Don't like it.
Vince Clortho, why was my membership super chat shown? Why was it?
Or do you mean wasn't?
Why wasn't? Did you have one?
Did we miss it?
You had the one yesterday. It was there, wasn't it? Oh, huh.
Jack's Delight says he'd like to see me on the stand. I've been deposed once. And it didn't go well for that lawyer. I still have the transcript. I pull it out occasionally and read it just for a laugh.
Thank you. That is so far back there. It's too far back for me to scroll, so I will just read it. I apologize for that. I can bring it up here on the other one, but I can't show it up. Vince Clortho, I apologize. Thank you for bringing to my attention that I missed that. It was right after Cheesehead. That's why they think why do we care what juror number 1's wife thought? Vince Clortho, who's been a member for 8 months, says JHACH hired English Bob as lead attorney, one of Gene Hackman's best roles. English Bob. I'm drawing a blank. English Bob, Gene Hackman.
I've not seen that.
Oh, and Unforgiven. Okay, I didn't know that was his name. Oh yeah, that was a fantastic role. Just for some reason, the fact that his name was English Bob skipped my notice.
My memory is so bad because of ADD. I know I've seen that movie, but I have no recollection of it. That's the great thing about ADD, though. You can rewatch things over and over again and never get sick of it.
Well, see, that's me. I remember plots. I don't remember character names. So everybody's like, "Yeah, what was that character's name?" I don't know. Or I go, "Yeah, that one guy in that one movie that did that one thing. That was awesome." All right. Sorry about that, Vince. In the court's view, defendant waived the ability to request an inquiry into the facts set forth in the third supplement because the supplement was filed more than 15 days after the verdict. The court found the request for inquiry regarding the facts of the second supplement waived, both because it passed the 15 days and because defendant had a copy of the notes in question before the verdict was entered. Well, respectfully. And whenever a lawyer says respectfully, they mean fuck you.
Up yours.
Respectfully, Judge, this court ruling on waiver is legally incorrect.
I love them telling him that. How much do you think he likes that, being told he's legally incorrect?
Not at all.
It's so cheeky of them. Respectfully, you are legally incorrect, even though you're the guy in the black robe. These people are insufferable.
And this gets me. With respect to the court's ruling that the jury note issue is waived because defendant failed to raise it prior to the verdict, it is unreasonable to expect the defendant would be able to scrutinize handwriting irregularities in juror notes in the midst of a 7-week trial. Well, I mean, you've been highlighting and you've been pointing out how egregious this is. Why, when you looked at it, you go, "Holy Jesus! There's SS marks all over this note." If it was that big of a deal, how come you didn't notice that?
Because they didn't see it until Reddit made a big deal out of it. That's why.
Yeah.
Because they're liars.
That may be it. Furthermore, until the extent of juror number 1's pro-plaintiff, anti-defendant bias came to light, the meaning and context of the Nazi symbol used on October 12th note was nearly impossible to appreciate. Well, if it was nearly impossible to appreciate, perhaps it shouldn't be appreciated at all. If this court had observed these versions of Dr. Smith's name at the time, it would have been impossible for this court to rule on November 6th that it had not seen anything in my mind that would remotely come to me to get to the conclusion that he had prejudged anything in this case. Simply put, there's no evidentiary basis in the record to find that defendant made a knowing waiver of the right to use his evidence to challenge a juror who has prejudged this case because it did not. It was still more than 15 days. Oh, okay. Well, here we go. All right. I want to hear this. The rule says must be known 15 days. It must be made within 15 days. And this wasn't. So let's find out why 15 days doesn't mean 15 days, shall we? Requires a motion for an order permitting the interview a juror must be filed within 15 days after rendition of the verdict, unless good cause is shown. So the good cause doesn't mean, we didn't notice it. Oh my God. I don't, that's all right. That's where they're going to go with it. The motion must identify the juror to be interviewed, the grounds for blah, blah, blah. All right. Nothing in the rule prevents a party from supplementing a timely filed motion with additional evidence supporting the identified grounds for challenge before the motion is decided. Okay. They're saying with the initial thing was filed within 15 days. We're just supplementing it with additional information and additional grounds. Grounds. I've got a whole ground song that I'm trying to put to a montage, but anyway. Similarly, again, then they go into these grounds why the 15 days is irrelevant and why they should still be able to do it even though more than 15 days had passed. I want to get down to the questions that were asked. If your argument as to why 15 days doesn't mean 15 days is 6 pages long, that tells you got a shitty argument.
Yeah.
Jules Odyssey 2001. Oh, come on. That would be 2001. A Jules.
They're still going. It's incredible. The
are.
chat has a one-track mind sometimes.
Full Metal Jules.
That's a good one.
Nick Starro says EJ, the extra Jules. She's so extra. Unhung Hero. Put the Redditor who runs the Maya subreddit on the stand and search their devices. Oh, yeah.
Yeah, how would they feel if they were subjected to this? It's something that no one ever thinks about is the unintended consequences of getting what you want.
Yep. Jules, actually. Duncan Idaho says, Jeff, are you familiar with Studio Ghibli? And if so, would you recommend any of those movies to Megan? I know you've got all of them. Totoro is one of my favorite movies on the entire planet Earth.
Really?
Yes.
So Duncan is determined to get me to watch this.
Watch all of them.
How do I find them? Where do you get these? Are they online?
They've got to be online somewhere.
Okay.
Wherever they're online, they're online.
I'll have to look into it. I've heard some really good things, actually. People were commenting on my stream when we were talking about it and left me messages about how it was like one of the best movies ever. So I'll have to check it out.
Totoro's the representative. I mean, that's one of my favorite movies of all time, just hands down. But there's so many other good movies. Grave of the Fireflies is like, other than the original cartoon animated version of Watership Down.
Ooh, I remember that.
Yeah. Other than that, Grave of the Fireflies is the only animated movie that's just like ever reduced me to tears.
Really?
Yeah.
Of course, I don't watch movies to cry. I hate crying in movies.
Well,
And I
don't
hated
watch
Water-
don't watch Grave of the Fireflies. It's
All right.
it's
I
it's
hated
about
Watership Down, by the way. I hated it.
well, this is about a boy and a little girl that their whole families have been wiped out, and they're just like scrabbling around
my
the
God.
ruins, the ruins after the nuclear bombs were dropped. It's like a horrific movie, but it's sad as hell. It's very well done. Princess
IT
Mononoke is a good
just
one.
told me it's on HBO Max. So
Okay, there you go. Yeah,
Yeah.
Princess Mononoke is great. Spirited Away is weird. Howl's Moving Castle is one of the weirdest shows you'll ever see. It's great. Ponyo is great. They're all good. Just watch them all.
Okay.
That's it. All right, enough of that. Let's get back. Now you've got me getting Megan to go off track about off track stuff. That's like off trackception.
the chat is incorrigible. Don't you know this
I
by
know.
now?
I know. And before we jump back into the final one, Duncan Ido, thank you so much for the super chat. Now I'm imagining Shapiro saying in Shapiro voice, "Grounds, Your Honor. Grounds for sustainment. Is that a judicial determination, Your Honor? Do you have subject matter jurisdiction? Grounds." All right. Was that gay enough?
Not quite.
Hello, sailor judge. I'd like to sail to Tuft Island with you. How's that? Anyway.
Better.
That's better. All right. Good. All right. We need to get to stage B here. Stage B is the additional questions they want in.
These
Sorry,
questions
chat.
are so insane. Get ready.
Yeah, they are. 1,216 of you here now. So thank you so much, guys. Please like and subscribe. I know that I mentioned that like 17 minutes ago, but hey, I'd love to have your subscription because YouTube is asshole, and I like all the subscribers I can. All right, and Megan Fox too at meganfox.locals.com and Megan Fox Writer right here on YouTube. Go to her locals, go here on YouTube. Just subscribe to her because she's like 10 times funnier than me, and you can see
Oh,
what
stop
happens
it.
when she gets in.
But I am only 500 subscribers away from 25,000. That's exciting.
Get it, girl. 500 of you just like go over to Megan Fox Writer, right? Don't close this. Just bring it also up and subscribe to her. There's 1,200 of you here. We can get her up to that like right now, that fast. Okay. The current scope of juror number one's interview is insufficient to investigate the allegations of misconduct. Even plaintiff's counsel has conceded that if juror number one is simply asked whether he improperly shared information with his wife, he'll simply repeat the denials that he made before and during trial. Well, maybe because that's the fucking truth.
It's incredible to me how they just assume he's going to lie.
He's
Well,
going to lie. He's
what
going
do
to
they
lie.
What do they know about this man? Nothing. They're just dragging his character. The man's was an LEO for I don't know how many years, but former law enforcement. He's probably one of the least likely people to lie in court under oath. He knows the consequences. Well,
All right. I have to
not
stop.
really a lot of consequences.
I don't care if Jules likes it or not. I have to shut down this Jules thing right now because Hu Haman just won with Born on the 4th of July.
I can't
Haman-
believe they're still going. Romeo
Haman
and
just won.
Juliet.
I'm sorry. Born on the 4th of July won. That's it. That's the winning one right there. All right, it's over. It's game over, man. All right. Given the strength of the evidence, that juror number one admitted multiple pieces of material evidence. Yeah, sure. In the jury form, harbored a pro-plaintiff bias during trial, failed to disclose his wife's extensive contacts with pro-plaintiff social media accounts. Born on the 4th of July. You know. Oh, my Lord, people. Stop it. Including her presence in the courtroom and friendship with plaintiff's advocate. Much more is required to determine whether defendant received a fair trial.
I hate that they
Well.
keep calling her plaintiff's advocate when the plaintiffs have already said that is not true. And he wrote
But
this
if you say it
after-
enough times,
right,
you know.
the dummies on Reddit will think it's true.
Oh my God. I seriously hope Jules is cool with all this shit going on. This is gonna be nice. Oh, I'm sorry.
I think she was enjoying it.
Well, she may have been enjoying it like an hour ago.
I would be enjoying it if I were her. It's funny.
All right.
Besides, this is her name's been thrown around so
I
much
know.
by
We
the
love Julie.
defense in such a defamatory, nasty way that it's nice to see the chat throwing her name around in a fun and entertaining way.
Because she's cool. Oh, she says no comment. Oh. Dun, dun, dun.
Yeah, you can do my name if you want. Go ahead. That'll be funny.
Jules has been the best sport through this entire thing. It's like
Yeah.
someone who literally just, I mean, I can't imagine how badly she didn't want to be involved in this. I mean, just, oh my God.
Well, you know what I was thinking yesterday? I was talking about this on stream, but it's like the thing I had not really considered. I was worried about jury intimidation and, making people scared to serve on juries is a big issue with what's going on. But it's also intimidating and chilling the rights of citizens to walk into an open courtroom and watch a case, cover a case, talk about a case. Imagine they are trying to pull her into this and actually they want her phone. That is terrifying. It is absolutely terrifying that these guys could even consider it, let alone maybe even get it. I'm not saying I think they will, but I mean, I think it really creates a chilling effect.
No, I think you're right. And that was one thing I was thinking about too, is we were concerned about the fact it's putting a chilling effect on people wanting to serve on juries. Now it seems like they're just like trying to keep people out of trials entirely.
Yeah. Right. It's like, oh, if you're too interested in a trial, you can now be called a plaintiff's advocate and be, thrown around in these motions and defamed. And that's really scary for people who are just court watchers, who just are interested in the process. And it should not be allowed. They should be kicked in the ass for this. And I don't see Judge Carroll doing it.
Well, in fairness, nobody's asked him to.
Well, yeah, I mean, the motion for sanctions that was like 300 pages. I still haven't read it, so who knows what's in it, because I still haven't read it because it's 300 pages.
Island says, thank you so much for your support. This trial is starting to feel like otherwise typical breakup that takes a turn when one side can't move on. Secondhand embarrassment is forming.
Yeah.
Right. And American Dreamer with the $7 super chat. Thank you so much for your support, American Dreamer. I love Jules when she first brought the rosary to court. Giving it to Maya was divine intervention by proxy. That's serious and funny at the same time. Thank you so much. Jules says we should be allowed to sue them legally.
Allowed to sue who? The attorneys? Good luck. These are very wealthy people.
Well, yeah, I mean, at this point, I'm willing to entertain an intentional infliction of emotional distress.
Oh, yeah.
Claim. But I mean, proving damages is the bitch. Like, oh, you became so super famous from this. You didn't suffer any. You were just benefited from it. That's what their response would be. But
they have no idea what the anxiety that an internet attack provokes. When people all of a sudden know your name, it's really upsetting. It's upsetting, and it provokes this anxiety in a person that is absolutely a physical response. And I know how she feels. I've had it happen to me, and it sucks.
And Christina, thank you so much for being a supporter for 10 months. Member for 10 months. That's very, very, very kind and generous. And Honey 2800, Tu Wong Fu, thanks for everything, Megan Fox. Honey, I haven't thought about Tu Wong Fu for a million years. Wow.
Yeah, Patrick Swayze in drag.
Matt Bond with $5 Aussie. Time to flood Jules' phone with pics of me in a bikini. No, it's not. No, nobody needs to or wants to see that. All right.
Please do not do that.
Let's look at the questions that they want to ask. So these are the court. The court must ask these following questions. They just must. Spouse communication during trial. Please tell us your wife's name. Does she post using the pseudonym Hippo Lover?
God.
See, but we know the answer to this, so why does it need to be asked? This is just them wanting to humiliate, embarrass, and intimidate people. That's the only reason you would ask questions.
I think they're trying to affirm that the juror himself knew about her avatar. That, like,
but we know
he's aware and monitoring her social media activity, like all good husbands.
Yeah. Does she use a hippo as her avatar?
Now you know why this next question is being asked.
I was going to make a really bad iced tea joke there, but I'm not going to. I love hippos. Anyway, does she use a hippo as an avatar? What devices does she use to access the internet and post online?
Well, they're asking that for one reason only. So that they can get the device. Yeah. There's no other reason to ask which device is used unless you are going to then file a motion for discovery to get that device.
Unless you know what it is, which means you're standing over her shoulder and you're watching her do it.
Mm-hmm.
If either your device or hers or a shared device is static, i.e. a PC, desktop PC monitor as opposed to laptop, where in your home is it located? Stupid question. Do you or your wife typically visit social media sites and post in a common area of the home, i.e. a living room or family room or veranda?
Veranda. Who has a veranda anymore?
I've got 4 of them on my house.
You 4 verandas?
Well,
or are they lanais?
Nope, they're verandas. 1, 2, 3, 4. Yeah, I got 4. Yeah, one right over here. Anyway, not balconies; they're verandas. Different. Do you and your wife typically? But who puts a computer on a veranda?
That's another. Where do you make these? I go to the veranda to make all my Instagram posts.
It's weird. We request that the post attached to juror number 1's motion be shown to juror number 1 and the following questions be posed. Have you ever seen the attached post? Which ones when? During the trial, are you aware that your wife was posting comments? Have you ever seen any of the posts made during the trial? When? During trial, was there any communication between the two of you regarding her online activity related to the case, whether verbal or nonverbal? Nonverbal?
I know. What is a nonverbal communication?
Yeah, I mean...
Yeah, are they playing charades a lot?
Yeah, 2 words. It's like... Did you later learn that your wife was posting during trial? When? Were you ever present when she was watching live streams or videos, reading information or posting online about this case, either before or during trial? Did you ever discuss your wife's post with her either before, during, or after trial? Did you express to her your approval of or agreement with any of her posts? Were you aware at the time that she was paying to accelerate or enhance some of her posts? Follow-up is needed regarding knowledge and form of payment used. I think she's talking about super chats.
Yeah, sir, do you control your wife's spending habits? This is the weirdest, most misogynistic questioning I ever heard.
Are you a real man of a husband, or do you just let your wife run willy-nilly around that internet? You know.
Yeah, how come you don't know everything she's doing online? And did you approve those posts before she sent them? What the hell is this?
Did you make sure her burqa had no wrinkles in it?
God forbid she should post a video of herself baking a cake in a fitted shirt.
Did you and your wife discuss the reference case before trial? Do you know if she posted regarding... Shut up, Megan. Do you know if she posted regarding the reference case before trial? Did you? Were you aware before trial that she favored plaintiffs? Did you? Were you aware... See, this presupposes it. Were you aware before trial that she favored plaintiffs?
Right.
That just presupposes she did favor plaintiffs.
Who says she did? Maybe she went into it not knowing anything and decided, like the rest of us did, that they were a bunch of lying coven, 7th floor coven witches
Okay, I heard lying covens. Oh God.
Lying coven
Yeah,
of witches.
I was like, no, not on my stream.
I didn't.
I know.
I was always going to say coven.
I know, but you just took a little too long between and
I'm
then,
sorry.
and
I'm
kind of
sorry.
freaked me out a little bit.
I'm sorry.
You scare me, Megan. You do sometimes. You scare me.
How come the Australians can use that word all the time and no one cares?
Because they're cool.
In an American accent, everyone goes bonkers.
Because they're cool. How did you? Okay, this is the spousal relationship with plaintiff's team. How did it come about that your wife was in the courtroom during the trial? She drove there. I don't know. Were you aware that she had plans to attend court? It's like, surprise. How did you become aware? When did you become aware? Were you aware of any communication between your wife and Jules during trial? Were you present during any such communications, whether verbal, nonverbal, or otherwise? Were you aware that your wife was meeting Jules during trial? Sounds like they're having an affair, for fuck's sake.
Meeting? I think they just sat next to each other one day.
Were you aware of your wife's presence in the courtroom? It's like, I feel her presence. She's here. She's floating over there.
I kind of would like to know the answer to that question, though, because I wonder, did he know she was coming there? Or like, did he look up and he was in the jury box and sees his wife in the courtroom? And what was that like? Maybe
Probably
that was
just drove there in the same car in the morning.
You think?
Like, honey, it's like take your wife to court day or something.
Yeah, maybe. I mean, she had a right to be there. She has a right to ride in a car with her husband.
Well, we just went from an affair to a seance. Now that we're in the seance portion of the questioning. Were you aware of your wife's presence in the courtroom? I feel her presence. What questions do you have for her? Why did you not disclose it? Because I don't fucking have to, you jackass. How's that for an answer? Did she communicate with Jules or Dr. Richards? Her presence was here. When she was in the courtroom, follow up as needed with questions regarding details of communication. Did she communicate with any witnesses for the Kowalskis? Did she have any communications during trial with any member of the Anderson Glenn law firm, any person associated with their teams? When did your wife first communicate with Nick Whitney, Greg Anderson, Jennifer Anderson, or any member of their firm? When did you become aware of your wife's communications with Nick Whitney, Jen Anderson, Greg Anderson, or any other member of their team? When did you first have contact with Greg Anderson, Nick Whitney, Jennifer Anderson, anyone of the 18 different versions of the same question? When did you first have contact with Jules outside the courtroom? When did you first have contact with Dr. Richards? When did you first have contact with Dr. Kirkpatrick, sorry. Do you know Deborah Salisbury? Yeah.
Oh, we sure do. We sure do.
How they dared even begin to contemplate filing this part of their motion.
I know.
After that affidavit was submitted.
Yeah, they're not smart. I mean, they're malicious, but they're not smart.
I mean, after that Salisbury affidavit was submitted, the word Deborah Salisbury would never ever fall from my lips again.
Never.
Or from my typewriter. Nothing. Oh my God. If so, how and when did you first become aware of her? Did you have any contact with Salisbury before the trial, during the trial, after the trial? Did your wife have any contact with Deborah Salisbury before, during, or after the trial? Recently discovered additional evidence of jury misconduct. Sorry, not jury misconduct, just evidence of misconduct.
So we did find out, Shapiro did say that an alternate gave him this thing. So an alternate sent him a screenshot of this document. It could have been an alternate who was more pro-hospital, I guess. I do wonder why stir up shit like that. Why give them ammunition, even though it's stupid ammunition? It doesn't work.
The note provides contact information. Okay, this is all stuff we've already talked about. Provides their contact information for everybody. And then it goes to, we've been given phone numbers of those you might wish to contact. And they have all said they would love to hear from you. Next to Nick Whitney's cell phone number is the following message. Please express our overwhelming gratitude for having delivered justice for Maya, Beata, Jack, and Kyle. All of the jurors fulfilled their solemn duty, and we are forever in their debt. After providing links to various YouTube commentators, Megan Fox included, that have followed and commented on the trial. The note concludes, and I'm noticeably absent. The note concludes with the following message.
Double bird
on appeal. Be careful. What is said about the media for Nick Whitney. No members of the defense legal team has initiated communication with any of the jurors, either directly or indirectly, nor has any member of the defendant's team attempted to deputize an online community, to take action that counsel in the case would be prohibited to take. The evidence suggests that the same cannot be said for plaintiff's counsel. The note delivers the message directly from plaintiff's counsel to the jurors, expressing overwhelming gratitude. The note demands, I want to see what the judge has to say about that. If he does. I have not read the denial other than like parts of it. And then
if I had to guess, he doesn't mention Nick at all. If I had to guess how that quote got in there, it was she reached out to Nick Whitney. Nick talked to her and asked her to pass on to her husband his gratitude. That's it. And then she passed on his statements to her, about what he said.
That's my thinking.
To the other jurors.
Yeah.
I don't think there's anything there. Nothing.
To juror number 1, have you seen this attached note? Did your wife deliver this note directly or indirectly to any of your colleagues on the jury, whether jurors or alternates? To whom specifically did she deliver it? Did your wife discuss the contents of the note with Nick Whitney or Greg Anderson or anyone from the office? Was your wife asked to send the attached note to the jury alternate? By whom? What was the response? Who responded? Questions for juror number 1's wife. Have you seen the attached? Same questions, but just to her. Did you speak with Nick Whitney? Okay, wait. Questions for plaintiff's counsel. These are the questions that they want to ask of Nick Whitney. Did you know that on November 6th, the juror number 1's wife had been in the courtroom a few days earlier? If so, how did you know? When did you meet juror number 1's wife for the first time? Where? Who initiated contact? Were you aware of the note written by juror number 1's wife? When did you learn of it? Did you suggest to juror number 1 directly or indirectly that she deliver the note to the jurors? How did juror number 1 obtain the message from Nick Whitney to the jury contained in the note? When? What did Nick Whitney say? Questions for Jack Kowalski. Oh, so they want him on there too. Gee, did you know his wife was? So what if he knows his wife's in there? During juror number 1's wife's there. During the trial, did he communicate with Jules? That doesn't matter. Did any communication include any reference to juror number 1 or his wife? Doesn't fucking matter. Have you ever had any contact with juror number 1 or his wife? If so, when did you make first contact with juror number 1 and his wife? Conclusion. Whew. Defendant realizes that the scope of this request regarding juror number 1 is unusual. Yes, it is. It's highly unusual, which is why you got your ass handed to you in the next order we're going to be reading the court. But this case is
actually bothers me.
But this case is extraordinary. And what are you eating? Just chomping on the air?
She's chomping on air. She's licking the air. Look at her looking at you like, what? What am I doing? Oh, Strawberry. She's so cute. This sentence is so dumb, Jeff, and it's going to make you mad too, and I'm sure you'll know why.
It does. This case is extraordinary in many ways, including the unprecedented traditional and social media attention it has received.
Let's see, Jeff, can you name off the top of your head at least 2 or 3 trials that got more attention than this one?
Nope, this is it. This is the only one that's ever got any attention by anybody ever.
The Johnny Depp Amber Heard case was so much bigger than this. There were hundreds of thousands of people watching at one time. The Rittenhouse case. I remember one time watching Nick's channel while he was covering the Rittenhouse case when it was getting really big. And there were like 50,000 people tuned in live to him at the same time. 50,000 people.
Oh God, Emily had over 100,000 daily.
This trial is nothing compared. We don't even have not even all of the lawyers are covering this trial, for God's sake. This is not even one of the, it's not even near the biggest trial or extraordinary in any way. But here's the thing. Shapiro and Hunter have just never encountered YouTube law entertainment sphere yet. They just don't know about this genre. They just found out about it because we're making memes about them. They have no idea we've been doing this for years. Yeah. And it's just insulting. It's like, what do you mean? It's not extraordinary. Get off. You're not special. Okay. Get off your high horse.
Nicholas Starrow's Trial Watch says Megan NATO.
I like that one. That's a good one. My name is a lot harder to put into movie titles than Jules. Jules's works a lot better, I've noticed. Yeah. That's probably why they're all doing it.
Daily Quick Bites is just like pulled complete fantasy out of his ass and has brought up a movie that would never be made. All Quiet on the Megan Front. That movie would never be made.
Quiet, quiet, quiet.
This is true. I promised Jeff that I wouldn't speak today unless spoken to.
We're doing good. We're not so far behind.
Oh, great. See, I'm doing all right.
We're funny, but we're also focused.
Oh my God, the Meg also it already exists.
There you go. That's just right there.
That one's one for the taking.
Melanie Schuyler says prayers for Kowalski's jewels. Juror number 1, hippo lover lawyers.
Yeah.
Seriously. All right. Conclusion. Continue. The detailed evidence of juror misconduct that has been exposed requires an inquiry sufficient to determine whether defendant received a fair trial or the integrity of the jury system was compromised. The limited scope of the interview contemplated by this court's December 20th, 2023 order is inadequate. So therefore, we need to ask more questions of everybody. The end. Well, take a deep breath here. We'll take a couple of minute breath while we just kind of shake it out. And I realized that
stretch. Should we do some squats?
Squats. An hour and 45 minutes ago, I poured a glass of water, and I haven't had a cup of water, which you can get from the merch store. This is my Legal Vices.
That's a nice mug.
Yes, it says this is a cocktail glass on the back.
I love that.
They didn't have cocktail glasses in the merch store, so that is the next best thing.
That's perfect.
Right. Well, we got through that stupid motion.
Let's get to the good one. But look, even though I like this order and I think that it's really well written and everything, and obviously the right thing to do, I still feel like it's a little too late to put a stop to what's been done to our jury system.
Sorry.
What?
The Long Island medium smart making.
That's
okay.
Good.
That wins that wins the Megan one.
Oh, that's pretty
Long
good.
Island medium smart Megan. All right, that's good. Planet of the Megans. Wow, that's kind of.
Why is my nail polish peeling off so quickly? What did I do wrong? Dang it! I just did this and I lost one already. Now I have to redo this one.
See, Jeff, you reached the conclusion and Strawberry turned around. She's ready for the next one.
I'm worried about her. She appears to be seeing things that aren't there.
Yeah. It's the presence of juror number 1's wife. She feels her presence.
Oh, God.
That's a dumb thing that bulldogs do occasionally. They call it catching flies. They just start.
Oh, this is a breed-specific thing that they do?
Yeah. It's just kind of like.
There must be a purpose for it.
They get bored. She's bored right now.
She's bored? Well, does she have toys that she likes to play with?
Yes, but they're all in the other room and she's too fat and lazy to go get them. But when we wrap up here, then I have like an hour to play with them until I go to sleep.
Aw. What is her favorite thing to play? Does she like tug of war?
Just anything. Oh, let me see. I got a bone. There's a bone here. Hey, there's something for you to chomp on. There's something for you to chomp on.
She does seem more awake than I've seen her recently. It's like kind of amazing.
She's usually just snoring.
All right. Yep, she wants my attention.
A doggy treadmill. That would be cute. Oh, God, wouldn't that be fun? Just put her on a treadmill and put the camera on. That would be hilarious. Everyone would love that.
She'd take 3 steps and fly off the back.
No, you think? I don't think so. She doesn't like to walk?
Oh, there we go. I gave her the bone here.
Oh.
No, their record is about a mile. And that took an hour.
They walk slow. Well, you can always put it on the slow setting.
Well, they just don't want. They're built for comfort, not built for speed.
They're so cute.
Short bursts.
My husband really likes bulldogs, but we've never had one. And now that We have Archie Ruckus. We may never have another dog again. He's ruined us.
Yeah.
He's just a ball of crazy.
That's the sad thing. Bulldogs have horrifically short lifespans.
Really? How long do they live? They've
just been so genetically warped by humans that 8 years ish. And like 10 is like a miracle, but then again, they get like 3 years old, they just drop dead for no reason whatsoever. And you don't think about it until you go, oh my God, I've had him like 6.5 years. Thinking, oh shit, you know, it was fine 6 years ago. Now I'm kind of sad because we're on the downhill slope.
How
Vin's
old are they?
6.5. So
Both of them? Did you get them at the same time?
Oh, they're brother and sister.
Oh, I didn't know that. Oh, Jeff, I'm sad now too. Dang it. Why did you have to bring that up?
Vince Clortho says, never again will I reply to a jury duty mailer. Reply, because I'll come looking for you.
You better reply, because there are consequences if you don't.
ARC5, thank you so much for your support, as well as Vince Clortho's. Well, I'm not thanking you for Vince Clortho. I mean, I'm saying thank you, Vince Clortho. And J1, did your wife pay to give the bulldog a snack? No.
Turn number one. Did your wife pay into a doggo cam?
I think she did, actually. Yeah, she did. She actually did.
Did your wife donate money for a doggo cam? Wait, it's like they just discovered YouTube. They have no idea how it works.
Yeah. Nah, that talking box you got over there on the desk.
Oh.
All right. I think we're all caught up here. We're all doing good, and we got 1,330 people here and 861 likes. Oh my God, we could get to 1,000 likes. We're only 140 away from 1,000 likes. That'd be awesome. If you haven't liked it, let's just play a game. Let's see, can we get the Lorax to 1,000 likes?
I can get you to that. I can get you to that.
No.
I can.
No. I know you can.
I held my chat hostage yesterday for 500 likes.
How's my the injury was everybody's like oh my God, that wasn't the point of my tweet. The point was they were playing Hakuna Matata in the gym while I'm trying to work out.
What?
Oh, you didn't read my tweet? No, I
didn't see that.
I tweaked the rotator cuff on my left arm. It's a little stiff, but I'll be back in the gym tomorrow. No, I mean I'm in the middle of like doing these bench presses, and suddenly just like they're playing decent exercise music, and suddenly like they start playing Hakuna Matata, and
it threw you off so badly that you tweaked your rotator cuff.
For some reason, it was just like the most ridiculous song to play in a gym while someone's trying to work out that I started laughing. And of course, when you're laughing with the bench press going, you lose all of your strength, which just makes you laugh more. And then
how do you not wear earphones at the gym?
Well, I have a personal trainer yelling at me the whole time, so I have to hear him.
Does he yell at you in English or Korean?
Oh, Korean, of course.
Nice.
And so it's either crush your windpipe or crush your chest, and then he's laughing because I'm laughing. And so all I could do was like dump the barbell to the left, and that kind of just tweaked my shoulder. That wasn't the point. Wasn't like, oh, I injured myself. It was like they're playing Hakuna Matata in the gym. I'm gonna actually start putting tweets about weird stuff I see in the gym.
You should.
Like, I mean, like in American or Western gyms, I've only been to other gyms in America. They're playing like heavy metal music, and they're showing their rock videos and things. Here they've got like on the video screens they're showing golf. Like if there's anything that's like more anti-workout, like inspiring than just
my
golf.
Gym shows the Food Channel.
That's
the Food Channel. It's cruel. I'm on the treadmill and I'm watching like Giada make this incredible, something Italian pasta. It's like, damn it. I've sworn off food. Do the Korean women in Korean gyms, do they film themselves in tight pants doing stupid things?
Not to the extent they do in America.
Yeah. I'm glad I never see that at my gym. I've never seen that. My gym is just full of like medium fat people. So no one is trying to be seen really.
All right. Well, before we lose more viewers, here we go. This is the reply. This is the judge's order. The order denying defendant's motion. So that whole long thing we just spent like about an hour reading, the judge just says, no. But he says it lengthwise. That's kind of a weird way of putting it.
Lengthy?
He says in a very lengthy manner.
Phrasing.
Right. Before the court without hearing is defendant John Hopkins, all children for reconsideration, blah, blah, blah. By order dated December 20th, the court granted a limited interview of juror number 1, which is set to occur tomorrow, January 3rd, 2024. The court explained to conduct limited juror interviews on 4 topics. The court also conducted JHACH's second and third supplements concluded that JHACH's second and third supplements were untimely. JHACH's current motion, JHACH takes issue with the scope of the juror interview permitted by the court. The premise of JHACH's motion is the unsubstantiated, again, when he starts off with unsubstantiated allegation, like the second paragraph, means y'all didn't prove shit. It's going to go downhill for you if you happen to be JHACH. Unsubstantiated allegation that juror number 1 will lie to the court and therefore the court's juror interview to be conducted tomorrow is inadequate. Yeah. So you just called juror number 1 a liar without providing any evidence he's going to be a liar.
And you called the judge's decision inadequate, which he's pointing out. Like, fuck you.
Yes. JHACH also contends that its second and third supplements should be deemed timely or at least find good cause for the delay. Finally, JHACH suggests additional improper communication between juror number 1's wife, plaintiff's counsel, and jurors. I like how he keeps their italics in that require additional inquiry.
Yeah.
JHACH in his motion concedes that his 3 supplemental findings were prompted by sleuthing conducted by the internet community. I like that. All the shit they accuse the defense of, they admit that it was done through the same means.
Mm-hmm.
The court will address JHACH's contentions based on the order presented. The order presented, JHACH presented them in its arguments. On the order presented,
I think that this.
He's saying I'm gonna answer it in the same order that they raised it in their motion.
Right.
Just See,
I think that this only got one. There's a couple of typos in this order, and I think it was put out hastily.
Because I was going to say, you know why? Because the judge is extraordinarily pissed because notice the timing of all these bullshit motions. They made the judge work through Thanksgiving, Christmas, and New Year's.
Oh my God,
they made him work through all 3 of these holidays.
And he's been working on this case for 8 years. I mean, this has got to really, you're right. I didn't even think about that. Yep. 3 holidays in a row. So I think, there's one presented too many in the sentence. It should say the court will address JHACH's contentions based on the order JHACH presented them. Exactly. But his clerk only got to go through it one time before he wanted it up. So there's a couple of typos you're going to find at going through this. But I think it's just because they wanted it up. He wanted it out before today. So
I mean, he cannot be happy that he had to work through Thanksgiving, Christmas, and New Year's.
And so did his clerk, by the way.
Yeah.
So did everybody who works for the judge on this. And this order has so much research in it. This took them a long time.
Yeah. Judges work? Are you kidding? Oh no, they do an extraordinary amount of work.
I'll be right back.
All right, good. Let's go here.
JHACH first argues. Good? Did you just say good?
Yes. Get back here. JHACH first argues that its original jury interview motion was timely, and therefore its supplements that added new claims were not timely should relate back to the initial motion. The court disagrees. Three sweeter words have never been spoken. The court disagrees. First, JHACH has not supplied any case law for its relation back proposition. Yeah, you said it, you just didn't support it. Second, JHACH's reliance on internet communities to conduct its own research does not transform an otherwise untimely supplement in a timely supplement based on good cause. Fair enough, exactly. Just because someone else does it and finds it later doesn't mean that we somehow suspend the time bar. Third, even if the jury interview rule permitted relation back, the subject matter of the untimely supplements were not remotely or substantively disclosed in the timely filing to permit there to a relation back. Saying, even if there is some theory to this relating back to the original filing of the original time the motion was filed. None of this that's raised in number 2 and number 3 was even remotely referred to in the first one. So you're not adding evidence to support the first one. You're bringing up 2 completely separate arguments that were not even remotely mentioned in the first one. Fourth, JHACH's claims in these filings are not material to the trial in this case. Like that one. They're just complete bullshit. That's all that's saying. As it relates to the wildly speculative claim, the judge is unhappy. When judges start telling lawyers that their arguments are wildly speculative, that's an indication the judge is pissed that you are wasting their time. Like thoroughly wasting their time. As it relates to the wildly speculative claim in the second supplement that juror number 1 was calling Dr. Sally Smith a Nazi, as evidenced by juror number 1's handwriting on a few capital S's on a jury question, and by extension implicating JHACH, nothing in the original motion or first supplement comes close to addressing that topic. JHACH's trial team included at least 5 attorneys and 2 paralegals, each of whom attended most days of the trial, in addition to whatever legal professionals JHACH had working behind the scenes. Oh, and you know they had a goddamn army of lawyers behind the scenes. You know they had an absolute shit ton of lawyers behind the scenes. One of the primary attorneys in JHACH's team who made substantial arguments before and during trials, a former chief judge and the Second District Court of Appeals. Under JHACH's theory, it necessarily follows that none of these highly experienced and knowledgeable legal professionals comprehended the meaning of the juror's note that they visualized and was in their possession weeks before the trial ended. Right. The court does not suggest attorneys have a monopoly on knowledge or reasoning skills. Far from it. I think you might be calling Shapiro stupid here. I'm not suggesting you have a monopoly on knowledge. Far from it. The court, though, makes the simple point in the circumstances in this case that JHACH did not show good cause to explain why its invocation of the alleged Nazi symbolism was untimely. This is especially true where Florida has a strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying. Yeah, breaking out the harassing jurors in the early parts of the motion kind of tells you how.
I'm glad he used the word.
Yep. And even if this issue were timely, or there was a good cause to excuse being untimely, there is no sworn evidence before the court suggesting that juror number 1 was invoking Nazi symbolism. Nothing about JHACH's pointing to the Simon Wiesenthal Center's website results in this conclusion, or even plausible suggestion that juror number 1 did what JHACH theorizes. Saying it confidently in a court filing does not make it so. Oof. He's pissed. This he hasn't said one nice thing in a single sentence here. Every sentence is just bitch slapping the defense. Oof. And suggesting the court's separate ruling on the juror disqualification motion would have been different had the court appreciated the obvious Nazi symbolism JHACH now believes existed by a couple of capital S's is unsupported. The court continues to find no objective evidence entitling JHACH to a juror interview on the Nazi symbolism issue, even if this issue were timely, which it is not. Yikes. As it relates to the alleged non-disclosure of juror number 1 or a family member being a victim of a crime, as asserted in the third supplement, this too is untimely, and there's been no good cause shown to excuse the lateness. In addition to JHACH's substantial trial team, defense counsel quickly solicited an untold number of unknown others to assist with JHACH's investigation of juror number 1. In a November 11th, 2023 internet post attributed to JHACH attorney Ethan Shapiro, which was a day and a half after the verdicts were released, Mr. Shapiro encouraged a pro-JHACH internet community to investigate juror number 1.
Oh, hell. Yeah. Oh,
no!
boy. Oh,
hey,
boy.
I want to thank you and everyone else who is sleuthing this so carefully and meticulously. I've gone through the Reddit threads on juror number 1 with almost 1,000 comments. Everyone on the defense team is monitoring this closely. If anyone in the community has comments to make, You can feel free to keep posting there because we're going to read all of it and put it towards emotion. Sick. Emotion. I agree that the idea the wife knew that when a verdict was coming and what they were arguing about is shocking. And I hope the judge will feel the same way. What goes around comes around. Through an unintended... Yes.
I'm hoping locals can pull up the Reddit response to that because they like took it as marching orders.
Oh yeah, they did.
So locals, if you can find that, post it for me and I'll show Jeff.
Yeah, I saw that. That's
you
back
did?
that's back when I first became aware of them.
Ah.
And they were hating on us originally there because we were laughing at all of this. Through an unintended mistake, it appears juror number 1's name was publicly visible for a short time on the court's docket the afternoon of November 9th when the Phase 1 verdict form was published. Despite this army of internet detectives, JHACH relies on the theory that the alleged criminal assailant shared the same last name of juror number 1's new wife, which was different than juror number 1's last name. This simply does not demonstrate good cause, regardless of the legion of individuals working on JHACH's behalf to investigate juror number 1. Even if this issue were timely, or that good cause had been shown, JHACH has not shown the alleged non-disclosure was material to the jury service in this case. So yeah, just haven't shown it was relevant. Materiality must be analyzed case by case. A juror's non-disclosure of information during voir dire is considered material if it is so substantial that if the facts were known, the defense likely would preemptorily exclude the juror from the jury. Question 18A is on the clerk's form. This is why we double space things. These single space lines get kind of cramped. It's not even a proper formatting. That's how rushed they were to get this thing out. Question 18A is on the clerk's form jury questionnaire, which is in the form used in both criminal and civil cases. The question was not on the special questionnaire used for this trial. Question 18A asks if the potential jury or family members had been the victim of a crime, which tends to be more relevant in criminal cases. The current case, of course, is not a criminal case. JHACH's own actions during the individual questioning of potential jurors demonstrates the contents of question 18A was not material. Critically, JHACH never discussed with the potential jurors the subject of question 18A. So in other words, all these questions about if you've been the victim of a crime are completely irrelevant.
Mm-hmm.
This is a civil case. It doesn't matter. The court conducted 3 days of individual voir dire, followed by 1 day for group voir dire. The court has transcripts of days 1 and 2 in the individual questioning, which are being filed concurrent to the release of this order. Ultimately, no one from day 3 of the individual questioning was a juror alternate, so the court is unaware whether any party has paid to have the individual voir dire form that day transcribed. The court has reviewed the day 1 transcripts, something that Shapiro didn't do. When he said, if this would have happened, I would have asked more questions. Well, did it happen? Well, I don't know. I don't know because I didn't look at all of it. Said, well, here you are making assertions, and you haven't even done your homework.
Imagine this: the judge called for the transcripts. The judge goes through the transcripts to find out if Shapiro did what he asked him if he did. It is so unacceptable that the defense attorneys did not look at the transcripts themselves first before making this argument. They made the judge do all of this extra work over Christmas and New Year's. I hate them for that.
And the judge probably does too. So the court reviewed day 1 transcripts. Despite having the opportunity to ask questions, JHACH never asked a single question of any prospective juror concerning a yes response to question 18A. Although the court does not have the day 3 transcript, the court does not recall JHACH asking any questions of a prospective juror concerning a yes question to 18A. In fact, the word victim was uttered a grand total of 1 time during the entirety of day 1 and day 2 by Mr. Anderson in a different context. See day 1 transcript.
Yeah, that's hilarious. And it was by Mr. Anderson.
Yeah. So in other words, the word victim never escaped the defense lawyer's mouth at any point in time during the voir dire.
Mm-mm.
The court notes on day 1, a total of 12 prospective jurors answered yes to question 18A. Of these 12 prospective jurors, 5 prospective jurors advanced to the group questioning stage. On day 2, a total of 14 prospective jurors answered question 18A is yes. Of these 14 prospective jurors, 4 prospective jurors advanced to the group questioning stage. A further note, 1 prospective juror, number 97, was seated on the jury, and 1 prospective juror, 137, was seated as an alternate juror. Defendant JHACH had remaining preemptory challenges at the time the jury was seated. So in other words, there were 2 other jurors that answered yes to this, and they were never asked any questions about it. 2 other jurors on the panel. When Shapiro testified that if anybody had answered yes to that question, they would almost certainly have asked them additional questions and possibly removed them from the jury panel. But nope, they didn't. On day 3, a total of 13 prospective jurors answered yes to the question. Of these 13, 6 prospective jurors advanced to the group questioning stage. And then we get a bunch of tables, which is good. The first table below depicts the potential jurors questioning answered yes, and then we go into all this here. Thank you for leaving that blank. We don't need to look at all this. Yay, we got to skip 3 pages, 2.5 pages. JHACH's current claim that the content of question 18A was material in this case simply cannot be reconciled by JHACH's actions. Or more precisely, in case you don't understand what we mean, JHACH, your lack of interest in the content of question A during jury selection. You weren't even interested in it.
You didn't even care.
You seated 2 jurors that's answered yes to that question and didn't ask them or anybody else anything about that. The lack of interest in the content of question 18A during jury selection, JHACH has not even attempted to explain why it did not ask any prospective juror answering yes to question 8 about the situation, why it did not seek to challenge any prospective juror for cause based on 18A, and why it did not exercise a peremptory challenge on either juror 97 or juror 137, despite having 2 remaining preemptory challenges. And a preemptory challenge is where you can say, I just don't want this guy on the jury, without a reason. You don't have to give a reason for a preemptory challenge. They still had 2 just carte blanche. I can just get rid of this person because I want to. Whereas other times you have for cause. Like if they, I'm a racist, and I'm totally I could never judge a black man fairly. Okay, you can go, there's a cause there. There's cause to remove you from the jury. But preemptory challenges, they're freebies. You get to get rid of them for whatever reason. And they still had 2 left, but they didn't even question the juror and the alternate juror who had answered yes to that question.
Seems like a problem.
There is nothing more than the proverbial Monday morning quarterbacking after knowing the results of the game. Yikes. That's good. I like that sentence. The court notes one final issue with respect to 18A. Juror number 1 marked yes to question 18B, which is whether he or his family member had been charged with a crime. When the court asked juror number 1 during individual voir dire concerning 18B, juror number 1 indicated his stepson had been charged with the crime. This is the same event that JHACH contends juror number 1 failed to disclose on 18A. JHACH had no follow-up question. That's literally the same exact scenario that they're saying juror number 1 did, and they didn't ask anything of that lawyer. They didn't ask anything of that prospective juror. Judge is not amused. Judge is unhappy. We need like grumpy cat with like morphed with the judge's face. When the court understands that a party is entitled to rely on a juror's response during voir dire and not conduct an exhaustive public record search at the time, under these circumstances, the court cannot find good cause to excuse JHACH's failure to raise the question 18A issue within 15 days post-verdict as required by the rule. And even if there were good cause, which there is not, JHACH has not shown the question 18A issue to be material to the case. JHACH is entitled to no relief on this claim. Before we get into section B, let's mention Walter Dedman here. Going back to the nonverbal communication thing, why, yes, I communicate with my wife via flags and Aldous lamps all the time. Little semaphore out there. Walter Dedman, and again, thank you so much for the additional support. Wow. All this deputizing the internet community makes me think of giving 4chan a badge and gun. Yikes. That's scary.
Yeah, that's super scary. No, thank you.
Oh, Strawberry has wandered off. And Cakes Boo, thank you so much. Thank you so much for the support. Deeply appreciated. I've heard many narrations on this end. You take them cake, Jeff. Hey, Megan takes the cake, but only if she wears like super tight tops. That's apparent.
I just posted on Twitter, I'm folding laundry live online while having boobs. Come at me, red-pilled weirdos.
Come at me, red-pilled weirdos.
So bizarre. Girls with big boobs just can't do anything these days, I guess. I guess it's all a thirst trap. It's just a thirst trap. Don't fall for the thirst trap.
Ignore this woman folding laundry. She's evil. Evil, I tell you.
She's evil because she has bigger than C cups. I don't know what is going on in the red pill world, but it's weird and it should stop.
You have no valid opinion, hussy.
Shut up, tramp.
Okay. Thank you so much, Cakes Boo. And Sebastian Mueller, thank you so much. In what ways can the judge tell Shapiro to go F himself? Well, he's telling Shapiro to go F himself in 14 pages that we're reading here. Every sentence is telling Shapiro to go F himself.
Jeff, do you think that the 14 pages is sending a message also? Because I've read orders by this judge in this case, and they've barely been over a page.
They're very short. This is a very lengthy order.
But is it
orders?
Girthy?
It is girthy. It's lengthy and girthy.
Well, what does that say to you?
Oh, it says he's extraordinarily pissed, and he's going to let every appellate court that looks at this order know exactly how pissed he is. He's going detailed. So he can't say this was overlooked, that was overlooked. He's hitting everything with this.
Yeah.
This is like, don't you even dare bring this to an appellate court kind of level of order. And Island. Thank you so much, Island. Straubs has had enough of the Shapiro BS. Fuck this shit, I'm out. Yeah, right. My face hurts. I've been reading. Shockingly.
Why does your face hurt?
Because I've been laughing and reading too much.
Oh, do you want me to read for a while?
Oh, no. We have to get through this.
I've been pretty good.
Fold your laundry, woman. Do your job. Fold your laundry.
All right.
Shockingly, JHACH can. Oh, this is the court scope of. Sorry. The court scope of juror interview is inappropriate. Shockingly, and again, when the judge refers to your arguments and uses the word shockingly,
it's probably not a good sign.
Yeah, it ain't a good sign. It ain't a good sign. Shockingly, JHACH contends by implication that if the court directly asks juror number one under oath or affirmation concerning the subject matter of permitted interview, juror number one will lie, and that an interview without invasive and extensive discovery will be worthless. JHACH wrote, we just read that, he's going to lie. These are incredible statements. There is scant, if any, evidence underlying these ambitious statements. That's a know your role, know your station. Do not get ambitious with me. This is judge is unhappy.
I don't believe you.
Before the
don't get brazen with me.
I love him so much, or at least I did
so
before
much,
he railroaded Zachary Anderson.
I know. I hate him so much too, but
I hate him now.
He still said some funny things.
I loved him back then, though.
Yeah.
I liked old Judge pre-head injury Schrader.
Pre-massive head wound, Harry.
Well,
all right.
He may need to be tested. He may have brain damage.
Well, he's retired now, so we don't care. As to the strength of evidence, quotes, in quotes, JHACH first points to juror number one's omitting multiple pieces of material evidence. The court above already demonstrated why the question 18A issue is waived and alternatively not material. As it relates to juror number one's answer to the DCF opinion question and answer about knowledge of attorney Deborah Salisbury, the court already has included those issues in the permissible topics. The court is aware of Ms. Salisbury's affidavit, which appears to further erode the strength of JHACH's allegations on that.
Oh, boy.
And by further erode the strength of, he means completely obliterates.
Obliterates. Yeah. I wish he had used a stronger word there. It seems to erode. Did he not believe her affidavit under oath? I mean.
Oh, no, he completely believed her.
Well, then he should have said so. He should have said it completely erodes that argument. That argument is dead.
That's the judge's nice way of saying it. That's the
I wish he would stop being so nice. Stop being so nice. These people don't deserve nice.
You still have to have decorum as a judge.
Oh,
You can't
fuck
literally tell
decorum.
them, and you literally can't say that, but there's clever ways of saying.
I don't know. I feel like he could have said that stronger. I think he could have said it completely erodes your argument there. That argument no longer exists. It doesn't seem to. It does. She's a member of good standing in the bar for 30 years. We believe her.
This is one of my favorite sentences. Next, JHACH replows the same infertile ground.
I know.
I like that.
This is good writing right here. This is good. What's the word? What do you call that?
Writing.
Now that it's a metaphor.
JHACH replows the same infertile ground that juror number 1 harbored a pro-plaintiff bias and otherwise formed a final and fixed opinion during the trial, contrary to the court's instructions. This was the subject of JHACH's November 2, 2023 motion seeking to disqualify juror number 1. The court previously rejected that premise during trial. We already talked about it. Stop fucking bringing it up. That's what he's saying. The reality is juror number 1 is a former law enforcement officer that JHACH welcomed into the jury despite having available preemptory strikes. And doing so is consistent with plaintiff's argument during jury selection that JHACH deliberately attempted to eliminate women from the jury based on their sex.
Ouch.
Yep. Regardless of JHACH's motive in keeping juror number 1 on the jury, juror number 1's question during trial demonstrated that he liked to confront witnesses with contradictory and disputed evidence, which in this case was legion.
He likes that word.
I am legion.
Regardless of JHACH's, I just like that. It's just he liked to confront witnesses with contradictory and disputed evidence, which in this case was legion. They do not show bias against JHACH or a violation of the court's instructions not to form a final or fixed opinion until deliberation. For instance, and focus more on time frame immediately before the disqualified motion, then they go through here and they just go through all the timeline, all the questions that were asked. And it just shows how much he liked to ask questions. They're just asking about photo after photos. He asked a lot of questions.
He asked a lot of questions, but I mean, and I have read through them, and all of them basically just illustrate that he was really thinking about this case through every angle you possibly could on both sides. And so these are all, the judge goes through every single one of them.
Good and bad for plaintiffs. Such as, yes, juror number 1 asked Dr. Cantu, who performed the medical-induced coma in Mexico, and about it being a highly controversial and unacceptable procedure. I mean, he asked questions, but the defense only dislikes the questions that go against.
Well, I mean, I think Greg Anderson said during one of our interviews that they didn't have a read on juror number 1. It could have gone either way for them. They had no read on him whatsoever, and if that's why he wanted to go with the alternate. He felt he had a better chance with the alternate, but Jack didn't, and so that was that. But Greg he didn't know. He said he thought it was a toss-up.
Yep, you're absolutely correct. I remember him saying that specifically to you during one of your interviews. In addition to these questions, there are numerous questions by juror number 1 that sought factual, clarifying information. While the court does not detail them all, the court sprinkles a few juror number 1 authorized questions near the end of the trial to show juror number 1's consistent behavior in seeking clarity in and challenging evidence. November 1, juror number 1 asked whether Nurse Flores took Maya Kowalski to the chapel and whether Maya Kowalski remained on the same floor except the EEG room. He asked Nurse Bali if she were employed at JHACH or the nursing industry and whether Maya Kowalski ever mentioned staff that she was not too keen on. And again, he just goes through and lists a bunch of questions. During these questions, the court does not mean to imply these were the only questions. By listing these questions, the court does not mean to imply that these were the only questions juror number 1 asked, or that juror number 1 did not ask challenging questions to both sides. Far from it, juror number 1, along with a couple other jurors, asked many questions, while some jurors only asked a few, and others were somewhere in between.
Jeff, is your microphone going in and out, or is it just me?
Is it?
It is. At least it is in my ears. I don't. Oh yeah, the chat says it is. It's fading out. It keeps fading out and coming back. Yeah.
Huh.
I don't know why. That just started happening. The volume, it goes loud and then goes soft and out.
Really?
Yeah.
Okay. My audio is dipping in. Is it still doing it?
I don't know. Keep reading.
All right. Well,
I'll tell
keep
you.
reading and let me know if it does it again. That's
Okay.
weird. You broke my flow.
Sorry.
Where are we at? No, but that was important.
Yeah.
Oh, some are, some aren't. Whatever. Weird. And some of those questions most certainly were uncomfortable to JHACH. But as the court observed during its ruling on the juror disqualification motion, why would juror number 1 ask so many questions if he'd already made up his mind? Oh, that's a good question.
Yeah, it is still doing it. It's
It is?
weird. Yeah, I don't know why. I've never heard that before.
Huh. Well, talk for a second because I'm going to unplug my microphone and plug it back in.
All right. During the court's ruling denying the motion for juror disqualification, the court had the benefit of having seen all of juror number 1's questions and observing juror number 1 throughout the trial. For instance, the court knows through its observations of juror number 1 that he took about a dozen legal pads full of notes. The jury went through so many legal pads, the court had to order more pads during the trial. We're going to need more legal pads. He constantly referred to his notes when formulating questions, and the court routinely had to wait for juror number 1 to complete the process of writing out his questions after the attorneys finished their questions. Can't hear you. Can't hear you. Okay, he says for me to keep going. The tonnage of information presented to this jury was immense. As the court is confident the trial transcript will show, whenever the transcript is finished being transcribed, the court was advised that it was ordered the day after the jury verdict and is still being prepared. The court could well see in real time juror number 1's efforts to make sense of difficult, complex, and very conflicting information being received by all jurors. That information gathering process at times may have seemed acrimonious to the parties, including JHACH, but it is consistent with the process the court sees many in law enforcement use routinely to test information given to them. How about now, Jeff? Still can't hear you. Nope, nothing. Tonnage is a good word. Tonnage describes what I saw on Twitter yesterday that I can't stop laughing about. Have you seen the fat girls on the polls? Because, oh my God, check out my Twitter page. Under our system of justice, we empower our juries to decide difficult cases. The jury's job is to determine what the facts are. Florida Standard Jury Instruction 601.1. They are permitted to... Oh, now we can hear you.
Oh,
You're
now
back.
you can hear me?
Yes.
All right. Well, that's good because I can't hear myself, but whatever.
What? Well,
it doesn't matter. I don't need to hear myself.
It sounds better now. It's not going out again.
I don't need to hear myself, so it doesn't matter.
All right.
I know what I sound like. It's just weird having.
But you can hear me.
Not being able to hear me. Yes, I can hear you perfectly.
Sadly.
Sadly. Yeah. Okay. Well, we'll just.
All right.
Something I'll have to. A reboot will solve everything, but I'm not going to do that right now.
We are at.
I don't know. Anyway.
We are at. They are permitted to use reason and common sense.
What the hell's that?
Under our system of justice, we empower our juries to decide difficult cases.
Right. The jury's job is to determine what the facts are. Florida Standard Jury Instruction 601.1. They're permitted to use reason and common sense and draw reasonable inferences from the evidence. Jurors are instructed they are to evaluate the believability of all witnesses. Provides. Let me speak briefly, but this is the jury instruction. Let me speak briefly about witnesses in evaluating the believability of any witnesses and the weight you will give the testimony of any witnesses. You may properly consider the demeanor of the witnesses while testifying, the frankness or lack of frankness of the witnesses, the intelligence of the witnesses. There's a lot of witnesses without much intelligence. And interest the witnesses may have in the outcome of the case. This means the opportunity the witness had to know the facts about which the witness testified, the ability of the witness to remember the matters about which the witness testified, and the reasonableness of the testimony of the witness, considered in the light of all the evidence in the case and in the light of your own experience and common sense. This is precisely what juror number 1 did in this case. He actually followed the jury instructions. Juror number 1's questions do not show bias. Instead, they show juror number 1's efforts to make sense of the material presented to him. Florida allows civil jurors to ask questions, governed by the same rules of evidence as the attorneys. In utilizing that opinion, juror number 1 was fulfilling his role as a sworn member of the jury. Few jurors have attended law school and should not be criticized if they preface their questions in a manner at odds from how an attorney would do it. That is why our process allows the attorneys outside the presence of the jury to object to a potential juror question, regardless of the niceties of the proper form. The judges and the lawyers, they have to follow niceties, but the jury doesn't. It would be the height of arrogance to think that a juror, and juror number 1 in particular, is somehow operating improperly because the questions asked do not fit neatly into either side's version of the case. Challenges what a witness says, presents conflicting evidence, or asks questions that raise issues not presented by the attorneys. I love these 1-line, 2-sentence paragraphs. This is like the Jesus wept part of the. That does not show bias. That shows the search for truth. Next paragraph.
He wants that highlighted and bolded. That's why he put that there. He could have put it attached to the last paragraph, but he wants it to stand out for a reason. I'm so glad you pointed that out. I did not see that the first time through, but you're absolutely 100% right. I love it.
Yep, that could very easily have been tagged onto the end of the previous paragraph.
Yeah, but he separated it on purpose to make it stand out. These are things writers do. I do that too.
We're approaching Megan's favorite part.
We are. I couldn't believe it. I was told that there was a Tuft reference in here, and I was like, I can't even imagine how he would do it. And when I got to this point, I lost my shit. My show could not move on. I
noticed.
I could not. I don't even know what happened after this. I have no memory.
Because I was like hoping to listen to you to kind of get a little heads up and to start forming some ideas and insights into what was going on, and that was completely useless.
I am sorry. I'm sorry, but this is epic for me. My show has reached epic levels. We've been, we're in the law now forever. We are in a court motion. Our jokes have made it into a judge's order.
Yes, they have.
And it does make me love Judge Carroll, because I loved him during the trial, and then I've hated him for a couple of weeks, and now I feel like he's personally reaching out to me here. He's like, I need you back. I need.
Well,
there's no better way to do it than make fun of the Tuft.
Let's get to it. JHACH, in his reconsideration motion, repeatedly asserted that juror number 1 was biased, as evidenced by his questions. The court rejected that theme in denying the juror disqualification motion and continues with that finding. I ain't changing my mind. Stop asking for it. That's what he's saying there. The court could not more fundamentally disagree with JHACH on this point. There's your everything you. That's this part. Where'd this part go? We all know what part I'm talking about. This part.
Everything that guy just says bullshit. Thank you.
That's what the judge is saying here. The court could not more fundamentally disagree with JHACH on that point, especially after watching juror number 1 throughout the trial. JHACH's repetition in saying that juror number 1 was biased based on the content of his question simply does not make it so. And stating forcefully, even repeatedly, does not make that statement correct. A quick analogy demonstrates this point. The undersigned could say he has a full head of hair.
I can't even believe this happened. We have reached into the courtroom and created a meme, and the judge is on board. I can't even.
Now, there's currently 1,441 people, or nearly 1,500 people, and we did hit 1,000 likes. That's pretty sweet. For those 1,440 of you in chat that may not have followed Megan, may not have watched her, she started calling his hair Tuft Island.
No, like Hair Island. Hair Island.
Yes, it was
Mo Mo
Yeah.
that came in with the tuft of justice at the end of the trial. But in the first 2 weeks, we were talking about it because you can't not notice it. The guy has a hair island, and
Yes.
Rob's chat was calling him the unicorn judge, but we started calling him Hair Island. It was like, does he comb the hair island? Like, is he putting gel in it? We were wondering, like, is the wife always on him about this? Like, just shave it off. Why is he holding on to this? It was a real topic of conversation.
And it just I just recommend everybody go back and watch Megan's stream from earlier. I guess it would be yesterday evening for you guys. It was earlier today for me. Go back and watch her yesterday's stream and just see how well it went over. Okay, a quick analogy demonstrates that point. The undersigned could say that he has a full head of hair. Whether said one time or 100 times, the reality is, as the undersigned's young son reminds, the undersigned has a small island of hair amidst a sea of baldness.
But he took the joke and made it even funnier. This is what I like so much about this, is that he made it funnier. He's funnier than we are. A small island of hair amidst a sea of baldness. It's so poetic. Oh, it's wonderful.
Saying the undersigned has a full head of hair does not mean the undersigned, in fact, has a full head of hair. I don't.
And it's hilarious that he's acknowledging that he knows he does not have a full head of hair. He knows this hairstyle is crazy, but he's hanging on to it. I gotta respect that. I just do. The tuft is becoming self-aware, someone said in my chat yesterday. It made me laugh out loud. Oh.
And I'm glad you just laughed about this for about 45 minutes, so that I got all of that out of my system before we got to this here. So we can move past.
We can move past it.
We can move past it. We got it all out of our system.
No one believed me that was really there. I had to like prove it to them that this is in this document. They thought that I had like photoshopped it in. I really didn't.
No. Burning Sensation says Jeff only has a sea of baldness. Hey, this is a choice. Well, I guess technically his is a choice too, but mine would actually be a sea of sparse hair, I guess.
Oh.
All right. I don't, he says. And juror number one's questions do not show bias against JHACH and do not show a final or fixed opinion prior to jury deliberations. Another one-sentence paragraph. JHACH began this section of his argument with his implication that juror number one will lie during the juror interview and points to the strength of its evidence of alleged misconduct to prove that assertion. The court understands that the standard to obtain and prevail at a juror interview is high and difficult for JHACH. That is by design. It's supposed to be difficult for you, JHACH, given the strong public policy against harassing jurors. That's the second time he's mentioned this. Or attempting to ascertain an improper motive to upset a jury verdict. Just because it is difficult, though, does not permit a party to wholly distance themselves from the facts of the case. The court's view of again, two-sentence paragraph coming up, the court's view of the proper scope of the juror interview is not impacted by JHACH's claimed strength of its evidence. There is no need for the court to reconsider the scope of the juror interview. The judge's like, I didn't have to consider it, but I'm arguing about it anyway. I like the judge. Oh hell! All right, the last part here, the post-discharge juror note. Finally, JHACH complains about his post-verdict note. JHACH contends was authored by juror number one's wife and distributed post-verdict and after the jurors had been excused as the jury in the case. In context, that note was apparently delivered later in time to a collection of already discharged jurors who deliberated and alternates who attended a dinner together. The post-verdict and post-discharge notice contained a statement of appreciation attributed to plaintiff's attorney Nick Whitney, together with various YouTube links to various YouTubers, including Megan Fox, meganfox.locals.com, and Megan Fox Writer here on YouTube. She's in the list.
I'm sharing a meme with you when you're ready for it. It's on the screen. This is what my chat made for the judge.
Hair Island. There's a story to it, though. There was like a narrative to it. It was even funnier.
Yeah, well, I made that up on the fly.
Did you?
Coming soon to Netflix, the story of a small hair island looking for love in a sea of baldness.
Wow, that was pretty good for you to make that up on the fly. I thought that was like something chat sweated over and
No,
presented
I
it
just
together.
made it up. I watch a lot of these reality TV
That was
love
good.
shows, so I have I have the narrative running in my head.
That was very good. Wow. Okay, so finally, so they gave this note at a dinner that all the jurors attended, or most of the jurors attended. This post verdict and post discharge note contained a statement of appreciation attributed to plaintiff's attorney Nick Whitney, together with various YouTube links to various YouTubers who commented on broadcasted the trial. JHACH suggests this is evidence of plaintiffs improperly contacting the jurors. There is nothing wrong about former jurors connecting with each other after discharge to discuss their shared experience. The court knows in scores of jury cases, some jurors, after they've been discharged as the jury, meet each other socially for drinks or dinner or other activities. Given the length of this trial, the court would have been surprised if none of the jurors or alternates met socially, even after being discharged.
You know what's funny? This is almost exactly what Peter said. Like, almost to, it's exactly what he said. So it's funny. It's like just more confirmation that it's totally normal.
Yep. Even assuming juror number one's wife distributed this note at a dinner after the discharge of the jury, nothing about the content of this note suggests any jurors or alternates violated any of the court's instructions or otherwise engaged in juror misconduct before or during the trial. As such, the post-discharge juror note is not indicative of any alleged juror misconduct and is certainly not evidence of plaintiffs asking the internet to investigate juror number one.
Ooh. So,
Ouch.
so I got to ask you, Jeff.
Yes.
The plaintiff, of course, has not been accused of investigating juror number one. The plaintiff was accused by the defense of trying to improperly contact a juror. Why do you think the judge worded it this way? He clearly knows that.
I think he didn't mention the misconduct the way it was put in the motion because that would just be the plaintiff's lawyers. That would be Nick Whitney's improper conduct, not juror number one's misconduct. And also because it certainly is evidence that defense were asking the internet to investigate juror number one.
I thought it was like a tweak there at them too. Like, I haven't seen any evidence of the plaintiff doing anything. Not like I've seen evidence of you doing it.
Exactly. I think that was clearly the one of the two reasons for putting that in there. Well, I mean, there was the one reason for putting that in there, and then there was the other reason why it was not mentioned about Nick Whitney's alleged misconduct. Conclusion: JHACH has not shown that the scope of the court's interview with juror number one is improper or insufficient. There is no basis to reconsider the court's prior order setting forth the only subjects for the juror interview. The court denies JHACH's motion for reconsideration. The interview will occur tomorrow under the conditions previously outlined by the court, done and ordered in Sarasota County, Florida, on January 2nd, 2024. Hunter W. Carroll, Circuit Judge. All the people involved. The end.
Oh, there was so much gold in that. I really enjoyed that order. I really have. Although I am still a little worried. Like I said, I wish he had come down harder on them sooner, because I do feel it's just done. Their actions have done a lot of damage. It has intimidated a lot of people, not just jurors, potential jurors. I did a poll, Jeff, on Twitter about how many of my followers would be intimidated to go on a jury now. 83% said yes, they're intimidated. 20-some% said no, I'd still do it anyway.
Why wouldn't they be? Why wouldn't they be intimidated?
And I'm worried about that. I don't know what can be done to fix that. I mean, I think that the judge needs to be way more specific. Instead of hinting at harassment, I think he needs to say, this is harassment. It has been harassment. There is no evidence of any of this, and you need to stop it. And I'm sanctioning you for doing it, because we can't send this message that courts won't protect jurors. So it wasn't enough for me.
Well, I mean, let's see what his final decision is on this. Let's see how his decision reads on this issue, and how things go on the sanctions side of things.
I don't foresee sanctions happening. I just don't.
I would kind of be surprised if they didn't, but I don't think they would be like just massive fines or things like that. But I mean, nominal fines. Like even in the O.J. Simpson trial and things, the lawyers were constantly getting fined like $700 for that, $1,000 for that. I can see some things like that. Just say, here, look, you messed up. We told you not to mention their identifying characteristics like their address, and that should have included their exact GPS locations. I can see them getting sanctioned for things like that. Or the damage is done. I mean,
that's what I'm worried about. I'm worried about the damage already being done. I don't know what can be done to stop it. I think the judge needed to come down on this a lot harder, a lot sooner. And I mean, I'm happy that he denied this one thing, but there's other stuff still out there. I think you're right about how the hearing's going to go today. I think it's going to be pretty quick and over with quickly. But just the idea that all the jurors now need to have lawyers on call, it's frightening. I've never seen this before. Have you ever seen anything like this before?
No, this is ridiculous. When Paula Young, Esquire, says, I kind of do see sanctions coming, the judge isn't going to let all of this repetitive argument go unchecked. Yeah, I mean, the judge is extraordinarily pissed off. I mean, that is plain from 14 pages. This could have been done in one page. Just, I've reviewed it and I find nothing, no support, no reason to change my previous rulings, my previous decisions. Could have been done very quickly. He went out of his way, and there wasn't a single sentence in there that was helpful to the defense. That was 14 single-spaced pages of handing them their ass. And I see some sort of sanctions coming. I don't see like soul-crushing levels, but something. And then we'll see how it's worded, because I think we're just kind of living in a new world now where this wasn't a thing before.
Well, what do you think causes this thing? Is it Reddit? Is it the wider interest in courts in general? What makes this okay for them to do, though? I don't understand why this would be all right.
I don't think anything makes it okay for them to do it, but I think it's just another tool to be used that people, another trick or tool, depending which side of it, just which side of the argument you have to be on, that another way to quote unquote aggressively aggressively argue in your client's favor. I think it's shitty and it's shady, and the ethics.
If I'm the client, though, and if I'm JHACH and I'm already suffering from a reputational, decline, the IJ thing comes out, the Heart Institute thing, surgeons not washing their hands, their reputation is in tatters. They're a joke. They're the butt of a joke. If I'm their PR team, the last thing I am telling them to do is continue this assault on juror number 1. I'm telling them to wrap it up, see if you can get the remitter, like take the amount down some. We know we're going to be paying, but let's stop with the personal attacks and try to repair what we have damaged. Because their behavior here is so bad. Their lawyers are they have been so bad that I don't see this ever going positive for JHACH in the law, in the public sphere.
I don't want to put words into JHACH's mouth, but these are their bulldogs. These are their pit bulls. These are the guys that go after you, me, Maya, everyone else, and try to destroy us in an effort to protect their corporate entities.
Everybody who's been involved in medical malpractice cases, people who have been contacting me and saying, now everyone sees what it's really like. This is what they do. And that's scary. That's really scary. If you've been harmed by a hospital or doctors, to know that if you try to fight them, this is what happens, is really scary to me. And I think it ought to change.
Paul Young saying, I don't really think, where do we go here? I don't think any of the non-juror number 1s really need an attorney. If they called me, I would advise them to wait out these post-trial motions, then give me a call. Oh, that's what I was saying at the beginning. I was saying if they haven't at least contacted someone and said, please stand by, I would be surprised. I mean, it's been focused around juror number 1, but maybe I'm just being the overly cautious lawyer guy. But I'd be, hey, I was on that jury. Can I call you if need be? And the question I get asked most often about this is, why didn't JHACH fire their defense lawyers? This is one loss. How many wins have they got? How many other souls have they crushed? How many other families have they devastated? And they almost succeeded in this one too. These same lawyers were actively involved in trying to split up the family.
And we have to start accepting the fact that Johns Hopkins, All Children's, wants this team. They want what's happening. They want these kind of tactics. And that's the thing that really saddens me. I want to be a person who has trust in our medical system. I want to be someone who feels safe to go to a hospital and that I'll be taken care of. And that if something were to go wrong, there would be a good faith effort to help my family. And help my loved one or whoever it is that's in the hospital. And now because of this, I feel like they're adversarial. I feel like it's an adversarial process instead of a cooperation. And that's devastating. It's devastating to think that our healthcare system has been so corrupted by, I don't know, is it love of money? What is it? You don't want to pay out if you harm somebody. You don't want to be held responsible for that. Well, you know what? Sorry, this is the real world. You need to be responsible when you harm somebody, when you kill somebody's kid, or your surgeons don't wash their hands and they spread disease, or you stock oxygen tanks in a way that they could explode. People expect you to say you're sorry and fix things.
Well, I mean, the example I use is one of my personal heroes, Jerry Spence. One of the greatest trial lawyers ever. He never lost a case as a prosecutor or a defense lawyer. And I think the last time he lost a civil case was like 1969. And he was defending Imelda Marcos, Karen. He was representing Karen Silkwood, like all these major cases. And he started out as an insurance lawyer. And it was his job to help his people, his clients, and the insurance companies not pay out. And he said there was a guy that probably deserved to get compensation, but he used his lawyerly skills and his lawyerly tactics to make sure this guy didn't get anything. And then he just happened to be standing in front of that guy in a supermarket checkout stand a day or two later. And the guy shook his hand and said, it's okay. I know you were just doing your job.
What a nice man.
And he said, I had to look at myself that next day in the mirror and go, is that really my job?
Did he quit?
And he quit, and he never did it again. He took up, that's when he started doing defense things.
Lawyers can do so much good in this world. Some of the best people I've ever met are lawyers, and some of the worst people that I've come across are also lawyers. And it's upsetting that when you have the power as an attorney to really make a change for good and to fight for people's rights and do good things, that someone becomes the type of attorney to harm people, that actually works on behalf. And I do understand that everybody deserves a defense and I get that. But it's unfortunate to me when you run across this kind of, I think you can defend JHACH without going so far over into what is unethical and defaming and attacking our entire system. I think there was a way to do this and give him a very good defense. And what's the word? Not vociferously, that's close, but what's the word they use for a robust defense? I think you could give them that without doing what has been done here.
Well, I know we've talked about it before, and especially as it related to the first supplementary motion when they're bringing up just this crap that happened 20 years ago. It's just because you can do something doesn't mean you should do it. And as we talked about then, is me as a lawyer, I as a lawyer would have to be able to look at myself in the mirror and know that what I put in that paper, what I put in that filing, what I signed my name to and swore that it was the truth to the best of my knowledge, what I would do that, I would have to be able to think that's the best work I've done.
Right.
That I'm proud of every single word I've put in that document. If I'm not, don't do it. And if Shapiro and everybody else on the JHACH team can actually look at these submissions they're making about juror number 1, his wife, Jules, the Nazi shit, the Nazi excrement, the things that they've put out on those in those documents and submitted to the court, if they can look at those and be proud of every single word, every single argument they've made, that just tells you there's a little bit of a missing moral compass somewhere.
Yeah, I would doubt that they're proud of it all. I don't know. I would then.
And if they're not proud of it, why
are
do
they
it?
doing it? Yeah, because of the money. They're getting paid huge money. They're making huge money. The vacations they take are to places and
or don't take because of the trial.
Yeah, they live a life that most of us will never see. I mean, they make huge money. But I is the love of money. I really do believe, and I've been in situations, I've never had a ton of money. Well, my parents were well off, but I mean, as an adult, I've never made as much money as my parents, and I've struggled. My husband and I shared a car, walked to the train. We've done all sorts, but it's fine. It's good. There's nothing about my life that I'd be like, oh, I'd be willing to sacrifice everything I believe in so that I could get a way bigger paycheck. I can't see that happening. And it's sad to me that people do. It's sad. I don't like it.
Well, and see, I can see ways in which JHACH could have come out of this looking like the good guys.
Right. Why wouldn't they want that is the question.
I mean, someone serves you a $261 million kick in the ass. That's when you do your huge mea culpa, and you go, "Oh my God, we realize now that we have a broken system. You sacrifice a few people to the the gods of common sense and courtesy and decency. You have your few sacrificial lambs. We've eliminated people. We're starting this restructuring. Here's what we're doing to make sure this never happens again. You shut up. You pay the deal. And again, I have no problem with them asking for the reduction in the
awards.
Either
do I.
Some of them probably deserve.
Legitimate. I think it's completely legitimate. They could have been like, we are so sorry, but we do have these obligations to the client. We do have to try and, reduce some of these payments, but we're in full agreement that this will be done. We're going to get it done as soon as possible and try to get the remitter and whatever. Fine. Nobody would have cared. What they are doing is
admit your problem, and you go appeal the amount all you want. Let the verdict stand. Give your mea culpas, give your explanations of what you've done to put safety measures in place to make sure this never happens again. You get rid of Susan Smith, you get rid of the coven. I keep saying Susan Smith, don't I?
Yeah.
I'm sorry, there's too many evil SS's out there. Yeah. There's too many evil SS's out there. Sally Smith and all the other members of the coven, as you call them.
If they had any moral compass, they would have settled with the family before this even went to trial, and then none of us would know the depths of JHACH's guilt here. We wouldn't know anything about the IJ. We wouldn't know anything about them dropping kids. We wouldn't know anything about any of this, and they put that aside. And they didn't care that we were going to know all of this inside stuff, all of this terrible stuff they've been doing, just because they truly thought they could win this. Wow, it's hard to even wrap my head around, Jeff.
I'm not fully sure on how. Now, if I recall, JHACH had offered a couple of settlements that were rejected by Maya's family for being too low. Is that correct?
They claim that they never offered a settlement.
Okay.
What that means is they never put one in writing. what was offered, or it was like, it would have been like, well, if my client were to settle,
Oh yeah, of course.
here's what we might offer, and it was always like a insulting bullshit. Probably less than $5 million, you know.
And why, I mean, one of the huge reasons why I think that didn't happen is because you had such an extraordinary plaintiffs team. You had such an extraordinary group of people that were there that did things that I mean, when you were interviewing Greg Anderson, the guy sold his house and downsized.
I know.
In order to be able to continue doing this. Who does that?
I know. Good, amazing lawyers like Greg Anderson and like Sean McMillan, who go to the ends of the earth for their clients because they know their clients are being wronged, and they can't sleep at night. They can't sleep at night because of what they know. That's the kind of people that you're talking about here. And yes, he sold the chat. I guess some of them didn't hear that. Yes, he had to sell his house. His wife, has been homeschooling their kids. I mean, there's been a tremendous amount of sacrifice that's gone on in their family. They have small kids like me. They have 3 children, similar ages as mine. I mean, this is a young family who has had an incredible amount of sacrifice because of this. Because once you get to know one of these families, and one of the reasons why I covered the trial in the first place is because of all the families that I had worked with over the years through these same issues. And once you find one and you've heard the story of, this horrible oppression they've been through, you can't just turn your back on them and say, well, good luck. He said to me, I've asked myself many times, why don't I drop this case? And it's because you just can't. You can't. When you see someone and you're the only one who can help them, it's just what you do.
And that's what I'm saying. I mean, that is one of the primary strategies and tactics of big corporations, is to bankrupt your opponent.
Starve them out. Yep.
Yeah, until they're awful. Like, okay, just drop the case. Just do it. I mean, you come to a point where you have to tell your lawyers, I'm sorry, I can't afford to pay you another dime. You can't do this anymore. It's destroying the family. That is an acceptable strategy to large corporations, is to bankrupt them and crush them. And
that's
what they did
wrong with our system.
Well, yeah, and the Kowalskis had the miraculous fortune of finding the team that they found, that would go to these extraordinary lengths that I frankly have never heard of in 27, 28 years, however the hell long I've been doing this.
I know.
Never heard of anything like that.
People are always saying to me, like with the Hernandez case I've been covering, the new medical kidnap in Georgia, people say in the comments, you got to find them a lawyer to take this on pro bono. And I just think, do you not understand? Pro bono is like a dream. It's like, yes, some firms have a pro bono budget, but they do not they do not ever take family law cases. They sometimes will take criminal cases. But most of the time, you will not find a lawyer to take anything pro bono, and you can't blame them for that, because lawyers have to eat too.
This isn't a speeding violation or a drunk driving deal. This is something that has consumed this entire team and the entire firm. There's likely dozens of people behind the scenes that we've never heard of and never will hear of, that were working on this case for literally tens of thousands of hours.
I bet it's been millions
nearly
of dollars.
A decade.
Millions of dollars for this. This is one of the reasons that I think our judicial system is failing people, because if you go up against if someone wrongs you who can just outspend you, 9 times out of 10, you're toast, unless you get a miracle.
And that's why they keep people like Shapiro and company on the payroll.
Yeah.
Because they know how to do that.
Yeah, keep it tied up in court forever. I mean, did you watch the Netflix documentary, Jeff?
I didn't before, and I just don't want to now.
Well, there is a part in it where It is hard to watch, but
mean,
I would
should
say
I
that
watch it?
I think it's worth it.
Okay, all right,
There
I'll watch
is
it.
there is a part in it that is really gut wrenching because they finally get in front of Judge Carroll and the date for the trial is set, and he calls a hearing because JHACH has thrown another wrench into the works, and he decides, nope, we can't go forward. I've set this entire thing, and I now cannot fit it into my schedule because of whatever this wrench is they threw in. And there's a scene of afterwards, Kyle goes, just, has a breakdown, and he says, when will this end? When will it ever end? And here we are watching them continue to do this, even after a jury has spoken to this family. It is torture. I don't think people understand what it's like to be dragged through 1 year of litigation, let alone 8.
And, with the appeals, it could be many more before a dime is seen by anybody in this case.
Right. And with the way they're acting, I thought maybe they would settle after this, but now I'm thinking, no, they're just going to keep doing this until they starve them out.
Let's read a couple of the super chats here that have about 7 of them that have backed up here. Vince Clortho, can you be on medical weed and still be on a jury?
I think in most states it's legal now, and I don't think anybody asks you, do they? Do they ask you on the form?
Well, if they find, I mean, I probably wouldn't have anybody on my jury that was, just because just don't want to get the munchies during the middle of the trial, man. No, I mean, would you even ask? I mean, I was trying to think of what would be asking for, like, on prescription medications.
I don't think they ask the jurors that. I think they ask them if they have any medical reason why they may not be able to serve for the entire amount of time. But I've never seen on a jury questionnaire anything about what you're taking.
To me, it seems like it'd be unusual to ask that. But Dallas Sander says, looks like judge justifying sanctions with this. I hope so. I absolutely, desperately hope so. And Jules says, I wouldn't serve on a jury now, but nothing will stop me from attending trials. The only difference is
I'm glad to hear that.
I won't give my observations to any other channels but my own. Until it's over, then I'll want you to channel.
Well, that's unfortunate. See, I said that too. I said what it's going to do is, some of us rely on people like Jules, who are local to go in and give us their observations and stuff, and it's going to make people scared to do that, and that's really. That sucks. NBC, you can't let NBC and Law and Crime be the only people who can get on the ground, reporting in trials. But Jules, I don't blame you. I don't blame you at all. But I think this is another fallout from what they've done.
Hospice justice sanctions coming. Yeah, and I hope so.
Doubt it.
And I mean, even no matter what sanctions they get, they're going to be a drop in the bucket to what they get from JHACH in this case.
I want to see them have to pay legal fees for Maya. I want legal fees for all this shit that they had to do since Thanksgiving, since after the trial. They should have to pay every bit of what Anderson has spent on this.
Purple AJ, member for 2 months. Thank you so much for the continued support over 2 months. Deeply, deeply appreciated. Horse Welfare says, I am a victim of medical malpractice. I am permanently disabled because of an ER doctor. The defense used very unethical tactics like the Dick defense. We're not allowed to apologize. We can't say, oh my God, yes, we made a terrible mistake. We're sorry and we'd like to make you whole.
Humanity is so screwed. It's so screwed. I mean, how can we not just see we're all the same? We're all people, and like people do make mistakes. If they had just settled this outside of court, they could have settled for a lot less than $260 million, I'm sure. I bet 50 million would have been, I bet 20 million would have been okay for them. But no, they can't just be normal.
And Horse Welfare also says, thank you for your compassion, chat. I do have a good chat. Legal Vices chat is a good chat. Well, and I don't have much respect for the insurance company lawyers, things like that, because when I mean, I think most people that follow my channel know that my older brother was killed in a drunk driving accident on New Year's Eve. It was like 2 days after his death. We hadn't even had the funeral yet. And the driver's insurance company called and wanted to settle for $25,000.
Oh my God.
Had a very, very interesting conversation with them about exactly what they could do.
Wow.
And I mean that was just, they just try to get you while you're weak, get you while you're pain, get you while you're not thinking clearly, and if not, you try to force you into bankruptcy. It's terrible. Vince Clortho, 80% of citizens here can't afford a $500 emergency. Yeah, so how are you going to afford the lawyers?
That's what I mean. It's stacked unfairly, and there must be some other solution. I think that the caps, you know how they have caps for awards? I think they should put a cap on legal expenses. So you can't do what JHACH did. Like you can say, let's cap it at time. You've got 2 years to wrap this up. And if you haven't wrapped it up in 2 years, you're done. Case dismissed. Like, I don't know. I feel like, why should you be able to drag someone for 8 years? 15 hearings it took them to hand over the phones and the text messages. 15 hearings. How can that be allowed? That's where you need to start cutting the fat there. Say, no, you don't get 15 hearings, you get 1. And if you don't turn over the phones after I ordered you to do them, we don't even have another hearing. You have to pay the attorney's fees and sanctions and all that other stuff until you turn over the shit that I told you to turn over. But Judge Carroll allowed them to do 15 hearings before turning over the phones.
Well, unfortunately, it's not that uncommon. I mean, like right now, I'm trying to think of the longest open case that we have in our office is almost 13 years. No, almost 14 years.
Oh my God.
It'll be 14 years in April. Wow. But that's already gone up to the Korean Supreme Court once and come back down again. And then the judgment, we're expecting the judgment at the end of this month. After 14 years, we're finally expecting it to come to an end.
Wow.
But yeah,
All About Shade has a very good question. What has to happen for interest to start? Well, the judgment has to be entered. The judge has to enter the order of actual judgment. So he has to get through all the appeals about remitters and all the other shit that he hasn't looked at yet or ruled on yet. And then he has to put the order in for the judgment and say, that's it. Now you pay.
And again, this is like no, go ahead.
No, I have nothing left. I'm sorry. I stepped on your.
I was going to say, like the way it works in Korea, I would assume it works in Florida as well, as the interest. There would be interest from the date that the tort happened. From the date, whatever gave rise to the claim happened, until the date of judgment or the date the judgment's finalized, and then a higher penalty rate of interest from the date of judgment.
Really?
Until it's paid in full.
I think in Florida there's actually, I'm not sure. I need to ask. I'll ask Greg. I thought that it didn't start until the judgment was ordered, and then it starts from that day. Although I could be wrong. Finding out what day that starts, that's a good question. I'm writing that down for him.
It's like what they'll do here is, like, from the date the incident that gives rise to your claim occurred, it's 5% from that date until the judgment, and then it's 12% per annum from the date of the judgment until it's paid off in full.
Florida's just went up to 9%. That's where Florida's is. So that's pretty big when it comes to 260 million. Even if it's less than 260, let's say it gets knocked down to 200, you're still looking at several tens of thousands of dollars a day.
What time is it in Korea? It's 2:12 a.m. So it's kind of about that time. It's about time for me to shut it down and give you all a couple hours break before everybody has to go and start watching the trial.
Yes,
the hearing.
The hearing.
Got to watch the hearing. And I'll Tomorrow I'm going to be doing O.J. Simpson with Chandler Remington. We do that every Thursday. I'll be doing an unboxing because all my bunch of boxes and stuff came from the States. We'll do an unboxing and an O.J. Simpson stream tomorrow. Friday I'll do the hearing. I'll review it then.
Well, coming up for me today, I've got 3 p.m. I'll be covering the hearing, juror number 1, live on my channel. And then tomorrow night, I will be back with Sean McMillan at 7:30 p.m. Eastern time. We will be doing part 2 of his new case, which is Meyer versus Rady Children's Hospital. Another very similar case to Maya Kowalski, CRPS, Ehlers-Danlos syndrome, same exact story. And it's unbelievable the hell they put this poor girl through. If you want to catch up on that, part 1 is already on my channel. Part 2 will start tomorrow night at 7:30. And I think that's all I've got going on.
Well, we currently have 1,367 people watching, and we have 1,140 likes, which is very, very nice. Thank you so much for all the likes. But anybody that hasn't smashed that like button, this is your last chance. While we shut down our like and subscribe poll for today. Again, I had a very clever, very well thought out poll, and I apparently didn't save it. And
the last second I had to made me LOL. So
yeah, I had to throw the current poll that we actually did get used today together at the very last second. So great. JHACH defense: 4% say dumb, 5% say dumber, 61% say dumbest, and 30% say it's a childish poll, but they are stupid. So that's how the poll ends today. We got through it, Megan.
Excellent.
All in one day. 4 motions in one day. 3 motions and a decision.
And I didn't interrupt too much, did I?
You did good. Proud of you, Megan. There was a good balance between, totally going off the rails and taking the corners a little sharp,
Yeah, I can obey when I need to.
I was surprised. I didn't think we'd get through it. Even me doing it by myself, let alone injecting you into the equation, but we managed to do it.
I love hanging out with you. I do. I love hanging with you, Jeff.
As always, I appreciate you doing it. Let's wrap it up, shall we? Is there anywhere to send us? Let's see where we can send ourselves here. Who is doing something that I think you might be remotely interested in? That's a YouTube Studio. Go to content.
Is Mo doing her Newsy News? She does Newsy News at 12 usually. She might be on.
I don't know.
Mo in the deep end.
Customization. Redirect. Add. No Mo.
That's
not that
bad.
I can see.
She's not feeling good. She had a tooth removed, so she's been in a lot of pain.
Well, we'll see where YouTube sends you. Let's just send you out into the wild. Whoa, hang on. Duncan, Idaho said, "Whoa, super chat, come on!" Oh, did I? Oh, yeah. Thank you. Geez, yeah. Big super chat here from Duncan. Just about missed. Sorry about that. And thank you for quickly using your 10-month clean and sober membership thing to remind me of that. Do you get excused from jury duty if you just declare you're a racist, a sexist, or you hate hospitals, or declare that your decision will be based only on what is most contrary to the rest of the jury? And that's kind of a way to get off. But see, I don't want to go on a rant. It annoys me when people like, hey, man, I didn't know how to get out of jury duty. Oh, now I understand it. But I mean, before this trial, I used to get annoyed because that's a responsibility. That's part of being part of America is serving on juries. I mean, it should be an honor. It should be a privilege, not something you try to avoid at all costs. And especially people that enjoy watching trials that are actually intelligent and are educated and want to be part of the system, not because they have an agenda, but because they're truly interested in it. Those are the people we need on juries. But yeah, I mean, if you go and just say dumb stuff, they'll probably let you go.
I think there's only a few legitimate reasons to get out of jury duty, and one of them could be juror intimidation. And if you truly feel like, this could happen to you, I think I would ask the judge, what's your policy here on juror intimidation, harassment by the losing party? Because I'm a little concerned.
Yeah. Oh, shoot. Well, mods, thank you for being here and doing all your moddy good stuff. Thank you. Deeply, deeply appreciated. Couldn't do it without you. Chat, you are the best chat on YouTube, hands down, bar none. If you haven't subscribed, please think about giving me a subscribe on your way out. Your subscription would mean the absolute world to me. Megan, as always, it's a pleasure.
You too,
Thank you,
Jeff.
chat, for being so supportive. And you with the super chats, with the monthly memberships, with the memberships, and just being here, talking to each other, making comments and engaging. It's all deeply appreciated. None of it's taken for granted. On that note, we will leave you, and I will see you tomorrow for O.J. Simpson closing argument breakdown with Chandler Remington at 9 a.m. Eastern. And Megan Fox will be seeing you over on Magel Fox. Nagels and locks.
Nagels and locks.
Nagels and locks. Megan Fox will be seeing you over
tired,
on
Jeff.
Megan Fox Writer in a few hours.
Yeah.
Starting 3 p.m. Eastern is when this hearing will begin.
I'll probably fire it up around 2:30. See you
All right.
guys.
Take care, folks. We'll see you later. Bye now.